Hey guys, welcome to the stream. Happy day after Labor Day here in the studio here at Fox 5 DC in Washington. It's September 4th, and we're going to jump right in to what you see on the headline there. The Senate confirmation, day one of the confirmation hearings for Brett Kavanaugh for SCOTUS. Right now it's happening. We already have some protesters that are being ushered out. Actually, right now, let's take a live look right now inside that Senate Judiciary Committee room. You can see people lots of crowds there gathering, and security there ushering people out. The media sure to jump on that and get the footage of them sort of storming out and yelling. So without further ado, we're going to jump right over there. We're going to take a split screen shot so you can see Senator Jon Cornyn present his opening statement. We're still on the opening statements right now, as of now, and they'll get into the questioning later today. Again, this is just day one, and we're going to be switching up the shot for you here and there so you can take it all in and hear Kavanaugh's responses, the opening statements, and the protests that are going on. As some of them screaming already that this is a, quote, mockery and travesty of justice, and others, of course, on the other side of that as well. So take a listen. We're going to jump right in, and we're here in the newsroom watching along with you. So let us know any questions or comments that you have, and let's get right to it.
The test of time today. Judge Kavanaugh has an unparalleled academic and professional record of service. Many will cite his education, his clerkships, his time arguing cases before the court, his experience working for the executive branch. But I think one of the most important factors to me is he's already exercised excellent judgment in marrying a Texan, Ashley, from Abilene. So I know he's a good judge. In fact, Judge Kavanaugh is one of the most respected and thoughtful judges in the country. I am disappointed that despite his exemplary qualifications and outstanding record, so many of our colleagues across the aisle have announced their opposition even before he was nominated. The level of disingenuousness and hyperbole, even by today's standards, is extraordinary. Members from the other side of the aisle, including some who serve on this committee, have claimed that confirming Judge Kavanaugh would somehow be complicit in evil and the result in the destruction of the Constitution. Some have even claimed that you testified falsely, we've already heard that alluded to, before the committee when you were serving our country in the Bush White House. I hope you'll have a chance to explain the apparent misunderstanding on the part of some senators. And I sincerely hope this week we can all take a deep breath. We're not doing very well so far. And get a grip and treat this process with the respect and gravity it demands. As others have alluded, the American Bar Association, which some have called the gold standard for judicial evaluations, have unanimously rated you as well qualified for service on the Supreme Court. And as we've heard, a number of lawyers and judges across the spectrum have talked about your qualifications and sung your praises. And I'm confident at the end of this hearing, your stellar credentials and your body of work as a judge will demonstrate that you properly understand the role of a judge under the Constitution. And I'm confident you will demonstrate that you will faithfully and fairly interpret the text of the law and the Constitution and dutifully apply them to the disputes that come before you. Finally, Judge, I expect we'll have a conversation or two about this book, which you contributed to, and the law of judicial precedent, because I know that there's a number of questions by members of the Senate about how you will regard previously decided cases in the Supreme Court. And I trust you'll give us a scholarly and detailed explanation of that and demonstrate that many of the concerns that have been expressed about a new justice coming on the court somehow wiping away previous decisions single-handedly, not even with the help of other members of the court, is just plain ridiculous. And we look forward to asking those questions and getting your answer. Thank you very much.
Senator Durbin.
Thank you, Mr. Chairman. Judge Kavanaugh, it's good to see you again. I thank the members of your family who are weathering this hearing. Thank you very much for being here today. This is a different hearing for the Supreme Court than I've ever been through. It's different in what's happened in this room just this morning. What we've heard is the noise of democracy. This is what happens in a free country when people can stand up and speak and not be jailed, imprisoned, tortured, or killed because of it. It is not mob rule. There have been times when it is uncomfortable. I'm sure it was for your children. I hope you can explain this to them at some point. But it does represent what we are about in this democracy. Why is this happening for the first time in the history of this committee? I think we need to be honest about why it's happening. I think it's the same reason why when I go home to Illinois after being in this public service job for over 30 years, I hear a question that I've never, ever heard before, repeatedly, as people pull me off to the side and say, Senator, are we going to be all right? Is America going to be all right? They're genuinely concerned about the future of this country. You come to this moment of history in a rare situation. You are aspiring to be the most decisive vote on the Supreme Court on critical issues. Justice Kennedy did that for 12 years. And you are called to that responsibility. And we realize the gravity of that opportunity and that responsibility. Secondly, of course, your record and the statements of others suggest there's real, genuine concern about changing life and death values in this country because you see things differently. We've heard that over and over again, and I think you must understand the depth of feeling about that possibility. And third, try as they might, I'm afraid the majority just can't get beyond the fact that there are parts of your public life that they want to conceal. They don't want America to see them. I think that's a serious mistake, and I'm going to make a suggestion at the end of my remarks. But over and above all of those things is this. You are the nominee of President Donald John Trump. This is a president who's shown us consistently that he is contemptuous of the rule of law. He has said and done things as president which we've never seen before in our history. He has dismissed the head of the Federal Bureau of Investigation when he wouldn't bend to his will. He harasses and threatens his own attorney general on almost a daily basis in the exercise of his office. And I didn't vote for Jeff Sessions, but I have to tell you, there should be some respect, at least for the office that he serves in. And it's that president who's decided you are his man. You're the person he wants on the Supreme Court. You are his personal choice. So are people nervous about this? Are they concerned about it? Of course they are. I'm sure there'll be a shower of tweets sometime later in the day, harassing people in the cabinet, people in the White House, maybe even dismissing them. And maybe he'll go after me again, be my guest. But the point I'm getting to is if you wonder why this reaction is taking place, it's because what's happening in this country. There are many of us who are concerned about the future of this country and the future of democracy. And you are asking for a lifetime appointment to the highest court in the land where you will make decisions, the deciding vote on things that will decide the course of history and where we are headed. The Senate has a constitutional responsibility to evaluate your nomination. We do know that before you became a judge, you were faithfully advancing the Republican Party agenda. I jokingly said in one of your previous appearances that you're like the Forrest Gump of Republican politics. You always show up in the picture. Whether it's the Ken Starr investigation, Bush versus Gore, the Bush White House, you've been there. We also know that before naming you, President Trump made it clear that he would appoint justices, only appoint justices to the Supreme Court who would overturn Roe versus Wade and the Affordable Care Act. Those were his litmus tests. Now, he didn't ask you the question. What he did was to delegate this responsibility to two special interest groups, the Federalist Society and the Heritage Foundation, and the other groups that are spending millions of dollars in support of your candidacy. They're confident that you're going to favor the interests of corporations over workers and give the president wide berth when it comes to executive authority. And your own law clerks, men and women you chose, men and women who wrote the words that had your signature at the bottom of the page, have told us what they think of you. One wrote in an article entitled, quote, Brett Kavanaugh said Obamacare was unprecedented and unlawful. That's from one of your clerks. Another wrote, when it comes to, quote, enforcing restrictions on abortion, no court of appeals judge in the nation has a stronger, more consistent record than Judge Brett Kavanaugh. Big corporate interests solidly behind your nomination. Chamber of Commerce, full support. And President Trump's, whose lawyers say they will fight any effort to subpoena or indict him all the way to the Supreme Court, that president seems personally eager to have you confirmed as quickly as possible. Why are your supporters so confident you'll rule on these issues as they wish? Why do they think you're such a sure bet to take their side when, in the words of one of your former clerks, this is no time for a gamble? Unfortunately, I don't think you're going to tell us much this week. It's interesting to me that people in your position write all these law review articles, make all these speeches, and come to this room and clam up. Don't want to talk about any issues, but that's what I expect. Instead, we'll be asked to trust that if you're confirmed, you'll have an open mind, that you'll follow the law rather than move the law in your direction of your views. I'd like to trust you, but I agree with President Ronald Reagan. Trust, but verify. I wanted to trust you the last time you testified before this committee in 2006, but after you were confirmed to the D.C. Circuit, reports surfaced that contradicted your sworn testimony before this committee. You said to me unambiguously, under oath, the following: I was not involved and am not involved in the questions about the rules governing detention of combatants. But later, just a week or so ago, you acknowledged in my office that you were involved. For 12 years, you could have apologized and corrected this record, but you never did. Instead, you and your supporters have argued we should ignore that simple declarative sentence which you spoke and somehow conclude your words mean something far different. You are a committed textualist, Judge Kavanaugh. If you're going to hold others accountable for their words, you should be held accountable for your own words. So after my personal experience, I start these hearings with a question about your credibility as a witness. I know from my history with you that things you said need to be carefully verified. And that brings us to a major problem. I won't retread the ground about all the documents that are being withheld, but I'll show you a little calendar here that's interesting. There's a 35-month black hole in your White House career where we've been denied access to any and all documents. 35 months in the White House. And I asked you in my office, during that period of time, President Bush was considering same-sex marriage, an amendment to ban it, abortion, executive power, detainees, torture, Supreme Court nominees, warrantless wiretapping. One of these issues bears special mention as we mourn the passing of John McCain. In 2004, 2005, I joined John McCain when he led the effort to pass an amendment affirming that torture and cruel and inhuman and degrading treatment would be illegal in America. As a survivor of unspeakable torture, John McCain spoke with powerful moral authority about American values during the time of war. You were in the Bush White House when that McCain amendment passed. The Bush administration did everything in its power to stop John McCain's torture amendment. Then after we passed it 90-9, a veto-proof margin, President Bush issued a signing statement asserting his right to ignore the law that John McCain had just passed in Congress. When we met in my office, you acknowledged that you worked on that signing statement. Yet we've been denied any documents disclosing your role or your advice to President Bush. I asked you if you wrote, edited, or approved documents about these and other issues while you were staff secretary. Time and again, you said, I can't rule it out. Judge Kavanaugh, America needs to see those documents. We cannot carefully review, advise, and decide whether to consent to your nomination without clarity on the record. The period of time when you worked in the Republican White House led to a change in position on an issue which we have to address directly. Your views on executive power and accountability have changed dramatically. When you worked for Special Counsel Ken Starr in the late 1990s, you called him, quote, an American hero for investigating President Bill Clinton. And you personally urged Starr to be aggressive, confrontational, and even graphic in his questions. We've seen your memo on that one. But a few years later, after working in the Republican White House, you totally reversed your position and argued that presidents should be above the law and granted a free pass from criminal investigation while in office. What did you see in that Bush White House that dramatically changed your view? What are your views about presidential accountability today? Judge Kavanaugh, at this moment in our nation's history, with authoritarian forces threatening our democracy, with the campaign and administration of this president under federal criminal investigation, we need a direct, credible answer from you. Is this president or any president above the law? Equally important, can this president ignore the Constitution in the exercise of his authority? You dissented in the Seven Sky case when the D.C. Circuit upheld the Affordable Care Act's constitutionality. You criticized the law, a law which this president has said many times he wants to ignore and abolish. And you said, quote, the president may decline to enforce a statute that regulates private individuals when the president deems the statute unconstitutional, even if a court has held or would hold the statute constitutional. This statement by you flies in the face of Marbury versus Madison, our North Star in the separation of powers. It gives license to this president, Donald John Trump, or any president who chooses to ignore the Constitution to assert authority far beyond that envisioned by our founding fathers. There are many people who are watching carefully. I'm going to make a suggestion to you today, and it won't be popular on the other side of the aisle. If you believe that your public record is one that you can stand behind and defend, I hope that at the end of this, you will ask this committee to suspend until we are given all the documents, until we have the time to review them, and then we resume this hearing. What I'm saying to you is basically this. If you will trust the American people, they will trust you. But if your effort today continues to conceal and hide documents, it raises a suspicion. I'll close, Mr. Chairman. I know you're anxious. When I was a practicing lawyer a long time ago in trial, and the other side either destroyed or concealed evidence, I knew that I was going to be able to have a convincing argument to close that case. What were they hiding? Why won't they let you see the speed tape on that train or the documents that they just can't find? You know that presumption now is against you because of all the documents that have held back. For the sake of this nation, for the sanctity of the Constitution that we both honor, step up, ask this meeting, this gathering, to suspend until all the documents of your public career are there for the American people to see. Thank you, Mr. Chairman.
Senator Lee.
Thank you, Mr. Chairman. Thank you, Judge Kavanaugh. And thank you also, Ashley and Margaret and Eliza, for being here. I'm going to start by saying that the fact that there is so much angst over a single nominee, a single judicial nominee, tells you everything you need to know about why it is that we need judges now more than ever who are willing to read the law and interpret it based on what the law says rather than on the basis of something else. It also tells you more than anything else you could need to know about the need to restore a discussion of civics in this country, to restore a discussion about federalism and separation of powers, about where power is concentrated and where it shouldn't be, and what the role of each branch of the federal government is and is not. Many of the comments, many of the outbursts that we've had today suggest that we need to return to some of those fundamental principles. And I don't care whether you're a liberal Democrat or a conservative Republican or something in between. These principles apply. They're principles to which we have sworn an oath, and they're principles that I think we would do well to restore and focus on once again. If ever we're to return to an era of civility, we will return to that era on the basis of those foundational structural principles within our Constitution. Over the next few days, Judge Kavanaugh, a number of members of this committee are going to ask you questions. Questions about cases that you've handled as a lawyer, cases that you've decided as a judge, about your record, about your qualifications. Well, on that point about your record and your qualifications, the suggestion that you misled this committee at any point in your previous hearings is absurd. And the absurdity of that suggestion will be borne out in the coming days. I am certain of it. Some of the questions that will be asked of you will, in fact, be fair, and others will be unfair. And I think it's important for us to acknowledge that at the outset. When you look back at history, answering these kinds of questions, this is sort of how the practice of holding these hearings began, so that senators could ask nominees how they might vote, how they might rule in particular cases. But this didn't always happen. In fact, it wasn't until 1916 that this even started. You see, there have been 113 justices confirmed to the Supreme Court so far. The first 66 were confirmed without even holding a hearing. The idea of a hearing is relatively new. It's about 102 years old. We went for between 125 and 130 years under our constitutional republic without ever having a hearing. But regardless, we started having hearings just over a century ago. The very first Supreme Court confirmation hearing occurred in 1916 with Justice Louis Brandeis. After Louis Brandeis was nominated to the court, some called for a hearing. Now, if we're honest with ourselves, if we're honest about history, I think a lot of this maybe had to do with some anti-sentiment fervor and the fact that Justice Brandeis was Jewish. But senators also wanted to determine whether Brandeis would use his seat on the Supreme Court to advocate for some of the things that he had advocated for as a private citizen, as a public interest attorney. They wanted to know how he might vote in particular cases. They didn't ask Justice Brandeis to testify significantly, but they did, in fact, ask some outside witnesses what they thought about his nomination. The next important moment, one could argue, occurred in 1939, when Felix Frankfurter became the first nominee to himself testify before the committee. At the time, Frankfurter was controversial in part because he was born overseas, but senators also worried that Frankfurter was a radical based on his defense of anarchists in court. So again, senators wanted assurances about how Frankfurter might rule in particular cases, in particular, what results he might reach in a particular type of case. Frankfurter, however, significantly declined to engage with senators on those topics and insisted that his public record spoke for itself. Justice Stewart's nomination in 1959 was another turning point. Senators seeking to resist Brown versus Board of Education wanted to grill Stewart on his views on integration. Others still wanted to grill Stewart about his views on national security. So senators turned up the heat a little bit more in that hearing. Like Frankfurter before him, Justice Stewart did not provide substantive answers to their questions. When they wanted to know how he might rule in particular cases, he appropriately declined, just as his predecessors had. 28 years later, 28 years after Justice Stewart came through this committee, the Senate considered Robert Bork's nomination to the Supreme Court. This was another significant turning point. And in my view, it remains something of a rock bottom moment for the Senate and for the Senate Judiciary Committee. Without getting into any of the gory details here, I think it suffices to say that Senator Ted Kennedy and Judge Bork did not agree on certain matters of constitutional law. And Kennedy's response was to savage, unfairly in my opinion, the results that Judge Bork would reach if confirmed to the Supreme Court. The history shows that over the better part of a century, the Judiciary Committee has gradually created something of a new norm, a norm in which members demand that nominees speak about specific cases in return for favorable treatment from the committee as the jurists are going through this process. Now, nominees, for the most part, have gracefully resisted trading confirmation in exchange for promises about how they might vote in particular cases brought before them. To give two famous examples, Justice Scalia refused to say whether Marbury versus Madison was settled law on the ground that it could come before him. And sure enough, last term in Ortiz versus United States, the Supreme Court considered a case implicating the scope of Marbury. Likewise, Justice Ruth Bader Ginsburg created the so-called Ginsburg standard. No previews, no forecasts, no hints. Every current member of the Supreme Court has adhered to a similar principle, what we might call the Ginsburg standard. Even though nominees have not caved to the pressure, I still believe that there are some aspects of the Senate's approach here that might do a disservice to the country and might be frowned upon by future historians. If senators repeatedly ask nominees about outcomes, then the public will be more entitled, or at least more inclined, to think that judges are supposed to be outcome-minded, that that's supposed to be their whole approach to be to judging, that that's supposed to be what judging is in fact about. But this, of course, undermines the very legitimacy of the courts themselves, the very legitimacy of the tribunal that you've been nominated by the president to serve on. Over time, no free people would accept a judiciary that simply imposes its own policy preferences on the country, absent fidelity to legal principle. There's a better way for the Senate to approach its work. This process, in my opinion, should be about your qualifications, about your character, and perhaps most importantly, about your approach to judging, your own view about the role of the federal judiciary. It should not be about results in a select number of cases. Now, you're obviously exceptionally well qualified. Even your staunchest critics would not claim otherwise. Your academic pedigree, your experience as a practicing lawyer, your experience in government, and your 12 years experience sitting on what many refer to as the second highest court in the land, the U.S. Court of Appeals for the D.C. Circuit. You are independent. You've written that, quote, some of the greatest moments in American judicial history have been when judges stood up to the other branches, were not cowed, and enforced the law, close quote. You've said that judges cannot be buffaloed, influenced, or pressured into worrying too much about transient popularity when we are trying to decide a case, and that one of the most important duties of a judge is to stand up for the unpopular party who has the correct position. And you've lived up to your words during your time on the bench. Everyone knows that you served in the Bush administration. And yet, when you became a judge, in only 2 years, you ruled against the Bush administration a total of 8 times. For you, it simply doesn't matter who the parties are. It simply doesn't matter that you may have worked for an administration before you became a judge. The only thing that matters is your commitment to correctly applying the law to the facts of any particular case. As far as your approach to judging, you have appropriate respect for precedent. You've co-authored an 800-page book on precedent that, among other things, explains that a change in a court's membership alone should not throw former decisions open to reconsideration or justify their reversal. You've explained that for precedent to be overruled, it must not be just wrong, but a case with serious practical consequences. You voted to overturn circuit precedent only 4 times during your time on the D.C. Circuit, and each of those cases, involved a unanimous decision reached by your colleagues. And you follow binding precedent, even if you believe that binding precedent was itself wrongly decided. You decide cases based on legal merits, not based on the identity of the parties, and certainly not based on any political beliefs that you may harbor. We've already heard that your nomination will somehow be bad for women, for the environment, for labor unions, for civil rights, for a whole host of other things that Americans hold near and dear. I have a laundry list of cases in which you've ruled for people in each of those groups. But there's a more fundamental point here that I think needs to be made. The judiciary's decisions are legitimate only to the extent that they're based on sound legal principle and reasoning. And ruling for a preferred party is not itself a sound legal principle. It's quite to the contrary. Jury-rigging decisions and backfilling legal reasoning to reach a particular result, a particularly politically acceptable result in a particular case, no matter how desirable that result might be in any instance, is not a legitimate mode of judicial decision-making. And no free people purporting to have an independent judiciary should ever be willing to settle for that. So my plea to my colleagues today is that we ask Judge Kavanaugh hard questions. I believe we're required to do so. The Senate is not and never should be a rubber stamp, particularly when it comes to issuing lifetime appointments, even lifetime appointments on the highest court in the land. But if you disagree with an opinion he's written, make a legal argument as to that issue. Explain why you think it's wrong. Don't complain about the results as if the result itself is proof that he's wrong when you separate out the result from the legal analysis, from the facts and how they interact with the law in that particular case. And don't ask him to make promises about outcomes in particular cases. If it's unacceptable for the president to impose a litmus test, it is surely unacceptable for the United States Senate to do so. Judge Kavanaugh, I look forward to your testimony, and I'm grateful to you and your willingness to serve our country and to be considered for this important role.
Senator Whitehouse.
Thank you, Mr. Chairman. When is pattern evidence of bias? In court, pattern is evidence of bias all the time, evidence on which juries and trial judges rely to show discriminatory intent, to show a common scheme, to show bias. When does a pattern prove bias? I wish this were an idle question. It's relevant to the pattern of the Roberts Court when its Republican majority goes off on partisan excursions through the civil law. That is, when all 5 Republican appointees, the Roberts 5 we can call them, go raiding off together and no Democratic appointee joins them. Does this happen often? The Roberts 5 has gone on almost 80 of these partisan excursions since Roberts became chief. That's a lot of times. And there's a feature to these 80 cases. They almost all implicate interests important to the big funders and influencers of the Republican Party. When the Republican justices go off on these 5 justice partisan excursions, there's a big Republican corporate or partisan interest involved 92% of the time. The tiny handful of these cases that don't implicate an interest of the big Republican influencers is so flukishly few that we can set them aside. let's look at the 73 cases that all implicate a major Republican Party interest. Again, 73 is a lot of cases at the Supreme Court. Is there a pattern to these 73 cases? Oh, yes, there is. Every time a big Republican corporate or partisan interest is involved, the big Republican interest wins. Every time. Let me repeat. In 73 partisan decisions where there's a big Republican interest at stake, the big Republican interest wins. Every damned time. Thus, the mad scramble of big Republican interest groups to protect a Roberts 5 that will reliably give them wins. Really big wins sometimes. I note that when the Roberts 5 saddles up, these so-called conservatives are anything but judicially conservative. They readily overturn precedent, toss out statutes passed by wide bipartisan margins, and decide on broad constitutional issues that they need not reach. Modesty, originalism, stare decisis, all these supposedly conservative judicial principles all have the hoofprints of the Roberts 5 all across their backs, wherever those principles got in the way of those wins for the big Republican interests. The litany of Roberts 5 decisions explains why big Republican interests want Judge Kavanaugh on the court so badly. So badly that Republicans trampled so much Senate precedent to push him through. So let's review the highlights reel. What do big Republican interests want? Well, first, they want to win elections. What has the Roberts 5 delivered? Help Republicans gerrymander elections. Veith v. Jubileer, 5-4, license to gerrymander. Help Republicans keep minority voters away from the polls. Shelby County, 5-4, and Bartlett v. Strickland, 5-4, and Abbott v. Perez, 5-4, despite the trial judge finding the Texas legislature actually intended to target and suppress minority voters. And the big one, help corporate front group money flood elections. Big money interests love unlimited power to buy elections, lobby, and threaten and bully Congress. McCutcheon, 5-4, counting the concurrence, Bullock, 5-4, and the infamous grotesque 5-4 Citizens United decision, which I believe stands beside Lochner on the court's roll of shame. What else do big influencers want? To get out of courtrooms. Big influencers hate courtrooms because they're lobbying and electioneering and threatening doesn't work, or at least it's not supposed to. In a courtroom, big influencers used to getting their way have to suffer the indignity of equal treatment. So the Roberts 5 protects corporations from group class action lawsuits. Walmart v. Dukes, 5-4. Comcast, 5-4. And this past term, Epic Systems, 5-4. The Roberts 5 helps corporations steer customers and workers away from courtrooms and into mandatory arbitration. Concepcion, Italian Colors, and Rent-A-Center, all Roberts 5. Epic Systems does double duty here because now workers can't even arbitrate their claims as a group. Hindering access to the courthouse for plaintiffs generally. Iqbal, 5-4. Protecting corporations from being taken to court by employees. Harmed through pay discrimination, Ledbetter, 5-4. Age discrimination, Gross, 5-4. Harassment, Vance, 5-4. And retaliation, Nassar, 5-4. Even insulating corporations from liability for international human rights violations, Jessner, 5-4. Corporations aren't in the Constitution. Juries are. Indeed, courtroom juries are the one element of American government designed to protect people against encroachments by private wealth and power. So, of course, the Roberts 5 rules for wealthy, powerful corporations over jury rights every time, with nary a mention of the 7th Amendment. What's another one? Oh yeah, a classic, helping big business bust unions. Harris v. Quinn, 5-4, and Janus v. AFSCME this year, 5-4, overturning a 40-year precedent. Lots of big Republican influencers are polluters who like to pollute for free. So the Roberts 5 delivers partisan decisions that let corporate polluters pollute. To pick a few, Rapanos, weakening wetland protections, 5-4. National Association of Home Builders, weakening protections for endangered species, 5-4. Michigan v. EPA, helping air polluters, 5-4. And in the face of emerging climate havoc, there's the procedurally aberrant 5-4 partisan decision to stop the EPA Clean Power Plan. Pattern. Then come Roberts 5 bonus decisions advancing a far-right social agenda. Gonzalez v. Carhart, upholding restrictive abortion laws. Hobby Lobby, granting corporations religious rights over the health care rights of their employees. Nevola, letting states deny women truthful information about their reproductive choices. All 5-4, all Republican. Add Heller and McDonald, which reanimated for the gun industry a theory a former Chief Justice once called a fraud. Both decisions 5-4. This year, Trump v. Hawaii, 5-4, rubber stamping the Muslim travel ban. And in case Wall Street was feeling left out, helping insulate investment bankers from fraud claims, Janus Capital, 5-4. Pattern. No wonder the American people feel the game is rigged. Here's how the game works. Big business and partisan groups fund the Federalist Society, which picked Gorsuch and now you. As the White House counsel admitted, they insourced the Federalist Society for this selection. Exactly how the nominees were picked and who was in the room where it happened and who had a vote or a veto and what was said or promised, that's all a deep, dark secret. Then big business and partisan groups fund the Judicial Crisis Network, which runs dark money political campaigns to influence senators in confirmation votes, as they've done for Gorsuch and now for you. Who pays millions of dollars for that and what their expectations are is a deep, dark secret. These groups also fund Republican election campaigns with dark money and keep the identity of big donors a deep, dark secret. And of course, 90% of your documents are to us a deep, dark secret. Then once the nominee's on the court, the same business front groups with ties to the Koch brothers and other funders of the Republican political machine file friend of the court or amicus briefs to signal their wishes to the Roberts 5. Who is really behind those friends is another deep, dark secret. It has gotten so weird that Republican justices now even send hints back to big business interests about how they'd like to help them next. And then big business lawyers rush out to lose cases, just to rush up before the friendly court pronto. That's what happened in the Friedrichs Janus episode. The U.S. Chamber of Commerce is the biggest corporate lobby of them all. For big coal, big oil, big tobacco, big pharma, big guns, you name it. And this year, with Justice Gorsuch riding with the Roberts 5, the chamber won 9 out of 10 cases it weighed in on. The Roberts 5 since 2006 has given the chamber more than 3/4 of their total votes. This year, in all civil cases, they voted for the chamber's position fully 90% of the time. And in these 5-4 cases I've highlighted, 100%. People are noticing. Veteran court watchers like Jeffrey Toobin, Linda Greenhouse, and Norm Ornstein described the court's service to Republican interest. Toobin wrote that on the Supreme Court, Roberts has served the interests of the contemporary Republican Party. Greenhouse has said the Republican-appointed majority is committed to harnessing the Supreme Court to an ideological agenda. Ornstein described the new reality of today's Supreme Court. It is polarized, along partisan lines in a way that parallels other political institutions and the rest of society in a fashion we have never seen. And the American public knows it too. The American public thinks the Supreme Court treats corporations more favorably than individuals compared to vice versa by a 7-to-1 margin. 49% of Americans think corporations get special treatment there. Now let's look at where you fit in. A Republican political operative your whole career who's never tried a case. You made your political bones helping the salacious prosecution of President Clinton and leaking prosecution information to the press. As an operative in the second Bush White House, you cultivated relationships with political insiders like nomination guru Leonard Leo, the Federalist Society architect of your court nominations. On the D.C. Circuit, you gave more than 50 speeches to the Federalist Society. That looks like auditioning. On the D.C. Circuit, you showed your readiness to join the Roberts Five with big political wins for Republican and corporate interests, unleashing special interest money into elections, protecting corporations from liability, helping polluters pollute, striking down common sense gun regulations, keeping injured plaintiffs out of court against corporations, and perhaps most important for the current occupant of the Oval Office, expounding a nearly limitless vision of presidential immunity from the law. Your alignment with right-wing groups who came before you as friends of the court, 91%. When big business trade associations weighed in, 76%. This, to me, is what corporate capture of the courts looks like. There are big expectations for you. The shadowy dark money front group, the Judicial Crisis Network, is spending tens of millions in dark money to push for your confirmation. They clearly have big expectations about how you'll rule on dark money. The NRA has poured millions into your confirmation, promising their members that you'll break the tie. They clearly have big expectations on how you'll vote on guns. White House counsel Don McGahn admitted, there is a coherent plan here where actually the judicial selection and the deregulatory effort are really the flip side of the same coin. Big polluters clearly have big expectations for you on their deregulatory effort. Finally, you come before us nominated by a president named in open court as directing criminal activity and a subject of ongoing criminal investigation. You displayed expansive views on executive immunity from the law. If you are in that seat, sir, because the White House has big expectations that you will protect the president from the due process of law, that should give every senator pause. Tomorrow, we'll hear a lot of confirmation etiquette. It's mostly a sham. You know the game. In the Bush White House, you coached judicial nominees to just tell senators that they have a commitment to follow Supreme Court precedent, that they will adhere to statutory text, that they have no ideological agenda, end quote. Fairy tales. At his hearing, Justice Roberts infamously said he'd just call balls and strikes, but this pattern, 73-0 of the Roberts Five, qualifies him to have NASCAR-style corporate badges on his robes. Alito said in his hearing what a strong principle stare decisis was, an important limitation on the court. Then he told the Federalist Society, stare decisis means to leave things decided when it suits our purposes. Gorsuch delivered the key fifth vote in the precedent-busting and union-busting Janus decision. He too had pledged in his hearing to follow the law of judicial precedent, assured us he was not a philosopher king, and promised to give equal concern to every person, poor or rich, mighty or meek. How'd that turn out? Great for the rich and mighty. Gorsuch is the single most corporate-friendly justice on a court already full of them, ruling for big business interests in over 70% of cases and in every single case where his vote was determinative. The president early on assured evangelicals his Supreme Court picks would attack Roe v. Wade. Despite confirmation etiquette assurances about precedent, Your own words make clear you don't really believe Roe versus Wade is settled law, since the court, as you said, can always overrule its precedent. Mr. Chairman, we've seen this movie before. We know how it ends. The sad fact is that there is no consequence for telling the committee fairy tales about stare decisis and then riding off with the Roberts Five, trampling across whatever precedent gets in the way of letting those big Republican interests keep winning 5-4 partisan decisions. 73-0, Mr. Kavanaugh, every damned time. Thank you, Mr. Chairman.
Yeah. Senator Cruz.
Oh, Chairman, I have some documents to support this. May I ask unanimous consent they be entered into the record?
They without objection,
Thank
so
you.
entered.
Thank you, Mr. Chairman. Judge Kavanaugh, welcome. Welcome to your family, to your friends, demonstrating your good judgment. Your wife was born and raised in West Texas, and you and she have been friends of Heidi and mine for 20 years. Thank you for your decades of public service. And I'm sorry that your daughters had to endure the political circus of this morning. That is, alas, the world that is Washington in 2018. I want to discuss what this hearing is about and what it's not about. First, this hearing is not about the qualifications of the nominee. Judge Kavanaugh is, by any objective measure, unquestionably qualified for the Supreme Court. Everyone agrees he's one of the most respected federal judges in the country. He has impeccable academic credentials, even if you did go to Yale. And you served over a decade on the U.S. Court of Appeals for the D.C. Circuit, often referred to as the second highest court in the land. So our Democratic colleagues are not trying to make the argument that Judge Kavanaugh is not qualified. Indeed, I haven't heard anyone even attempt to make that argument. Second, this hearing is not about his judicial record. Judge Kavanaugh has over 300 published opinions, which altogether amount to over 10,000 pages issued in his role as a federal appellate judge. Everyone agrees a judge's record is by far the most important indicium of what kind of justice that nominee will be. And tellingly, we've heard very little today from Democratic senators about the actual substance of Judge Kavanaugh's judicial record. Third, it's important to understand today is also not about documents. We've heard a lot of arguments this morning about documents. There's an old saying for trial lawyers: if you have the facts, pound the facts. If you have the law, pound the law. If you have neither, pound the table. We're seeing a lot of table pounding this morning. The Democrats are focused on procedural issues because they don't have substantive points strong enough to derail this nomination. They don't have substantive criticism with Judge Kavanaugh's actual judicial record, so they're trying to divert everyone with procedural issues. But let's talk about the documents for a moment. The claims that the Democrats are putting forward on documents don't withstand any serious scrutiny. Judge Kavanaugh has produced 511,948 pages of documents. That includes more than 17,000 pages in direct response to this committee's written questionnaire, which is the most comprehensive response ever submitted to this committee. The more than 500,000 pages of documents turned into this committee is more than the number of pages we've received for the last 5 Supreme Court nominees combined. Listen to that fact again. The over 500,000 documents turned over to this committee is more than the last 5 nominees submitted to this committee combined. So what's all the fuss over the documents that are not turned over? Most of those concern Judge Kavanaugh's 3 years as the staff secretary for President George W. Bush. Now, many people don't know what a staff secretary does, but that's the position in charge of all of the paper that comes into and out of the Oval Office. Critically, the staff secretary is not the author of the paper coming into and out of the Oval Office. That paper is typically written by the Attorney General, by the Secretary of State, by other cabinet members, by other senior White House officials. The staff secretary is simply the funnel for collecting their views and then for transferring the paper back and forth. In other words, those documents, written by other people, say nothing, zero, about Judge Kavanaugh's views, and they say nothing, zero, about what kind of justice Judge Kavanaugh would make. But they are, by necessity, the most sensitive and confidential documents in a White House. They are the documents that are going to the president. This is the advice and deliberations of the president at the senior level, and the staff secretary is the conduit for those documents. So why is it that the Democrats are putting so much energy in saying, hand over all of those documents? Because they know beyond a shadow of doubt that President George W. Bush's White House team is not going to allow every piece of paper that went to the president to be made public any more than any other White House would. Republican or Democrat, no White House would allow every piece of paper that went to and from the president to be made public. Indeed, there are rules and laws and procedures for when and how presidential papers become public. And the reason the Democrats are fighting so loudly on this issue is they're making a demand they know is impossible to meet, and by the way, is utterly irrelevant to what actually Judge Kavanaugh thinks, believes, or has said. It would open up all sorts of fishing expeditions to attack, relitigate George W. Bush's record as president and what various cabinet members and senior advisors might or might not have said. But it is, at the end of the day, simply an attempt to distract and delay. And indeed, the multiple motions we've seen from Democrats, delay this confirmation, that reveals the whole joke. Their objective is delay. So what is this fight about? If it's not about documents, if it's not about Judge Kavanaugh's credentials, if it's not about his judicial record, what is this fight about? I believe this fight is nothing more and nothing less than an attempt by our Democratic colleagues to relitigate the 2016 presidential election. 2016 was a hard-fought election all around. And it was the first presidential election in 60 years where Americans went to the polls with a vacant seat on the Supreme Court, one that the next president would fill. Americans knew who had been in that seat, the late Justice Antonin Scalia, one of the greatest jurists ever to sit on the U.S. Supreme Court. And it was the first time since President Dwight D. Eisenhower's re-election campaign that a Supreme Court seat was directly on the ballot. Both candidates knew the importance of the vacant Supreme Court seat, and it was a major issue of contention in the presidential election. Donald Trump and Hillary Clinton were both clear about what kind of justices and judges they would appoint. During all three presidential debates, both candidates were asked what qualities were most important to them when selecting a Supreme Court justice. Secretary Clinton's answer was clear. She wanted a Supreme Court justice who would be a liberal progressive, willing to rewrite the U.S. Constitution, willing to impose liberal policy agendas that she could not get through the democratic process, that the Congress of the United States would not adopt, but that she hoped 5 unelected lawyers would force on the American people. That's what Hillary Clinton promised for her judicial nominees. Then candidate Donald Trump gave a very different answer. He said he was looking to appoint judges in the mold of Justice Scalia. He said he wanted to appoint judges who would interpret the Constitution based on its original public meaning, who would interpret the statutes according to the text, and who would uphold the rule of law and treat parties fairly, regardless of who they are or where they come from. Then candidate Donald Trump also did something that no presidential candidate has done before. He published a list of nominees that he would choose from when filling Justice Scalia's seat, providing unprecedented transparency to the American people. All of this was laid before the American people as they went to the polls on November 8th, 2016. And the American people made a choice that night. Now, my Democratic colleagues are not happy with the choice the American people made. But as President Obama famously said, elections have consequences. Because the American people had the chance to vote, a national referendum on the direction of the Supreme Court. I've said a number of times that Justice Gorsuch's nomination and Judge Kavanaugh's nomination have almost a super legitimacy in that they were ratified, they were decided by the American people in a direct vote in 2016. And so the Democratic obstruction today is all about trying to reverse that election. They're unhappy with the choice the American people want. And there's a reason that the American people want strong constitutionalists on the U.S. Supreme Court. Most Americans, and I know the overwhelming majority of Texans, want judges who will follow the law and will not impose their policy preferences on the rest of us, and who will be faithful to the Constitution and the Bill of Rights. Justices who will uphold fundamental liberties like free speech, like religious liberty, like the Second Amendment. That's what this election was about. And if you look at each of these, let's take free speech. It's worth noting that in 2014, every Democratic member of this committee voted to amend the United States Constitution to repeal the free speech provisions of the First Amendment. And sadly, every Democrat in the Senate agreed with that position, voting to give Congress unprecedented power to regulate political speech. It was a sad day for this institution. Years earlier, Ted Kennedy, the great liberal lion, had opposed a very similar effort. And Ted Kennedy had said, "We haven't amended the Bill of Rights in over 200 years. Now is no time to start." Ted Kennedy was right then, and not a single Democrat in the U.S. Senate had the courage to agree with Ted Kennedy and support free speech. Indeed, they voted party line to repeal the free speech provisions of the First Amendment. That is radical, that is extreme, and it's part of the reason the American people voted for a president who would put justices on the court who will protect our free speech. How about religious liberty? Religious liberty is another fundamental protection that the Democrats in the Senate have gotten extreme and radical on. Indeed, our Democratic colleagues want justices who will rubber stamp efforts like the Obama administration's efforts litigating against the Little Sisters of the Poor, litigating against Catholic nuns trying to force them to pay for abortion-inducing drugs and others. That is a radical and extreme proposition, and to show just how dramatic Senate Democrats have gotten, every single Senate Democrat just a few years ago voted to gut the Religious Freedom Restoration Act, legislation that passed Congress with overwhelming bipartisan support in 1993, was signed into law by Bill Clinton, and yet 2 decades later, the Democratic Party has determined that religious freedom is inconvenient for their policy and political objectives. They want justices that will further that assault on religious liberty. And finally, let's take the Second Amendment. In the presidential debates, Hillary Clinton explicitly promised to nominate justices who would overturn Heller versus District of Columbia. Heller is the landmark decision issued by Justice Scalia, likely the most significant decision of his entire tenure on the bench, and it upheld the individual right to keep and bear arms. Now, Hillary Clinton was quite explicit. She wanted judges who would vote to overturn Heller, and indeed a number of our Democratic colleagues, that's what they want as well. Overturning Heller, I believe, would be a truly radical proposition. To understand why, you have to understand what the 4 dissenters said in Heller. The 4 dissenters in Heller said that the Second Amendment protects no individual right to keep and bear arms whatsoever, that it protects merely a collective right of the militia. The consequence of that radical proposition would mean that Congress could pass a law making it a felony, a criminal offense for any American to own any firearm. And neither you nor I nor any American would have any individual right whatsoever under the Second Amendment. It would effectively erase the Second Amendment from the Bill of Rights. That is a breathtakingly extreme proposition. It is what Hillary Clinton promised her justices would do. And at the end of the day, it's what this fight is about. We know that every Democratic member of this committee is going to vote no. We don't have to speculate. Every single one of them has publicly announced they're voting no. Doesn't depend on what they read in documents, doesn't depend on what Judge Kavanaugh says at this hearing. They've announced ahead of time they are voting no, and most of the Democrats in the Senate have announced that in the full Senate. But everyone should understand, Judge Kavanaugh has handed over more documents than any nominee. More than the last 5 combined, Republican and Democratic nominees. It's not about documents. It's not about qualification. It's not about record. What it is about is politics. It is about Democratic senators trying to relitigate the 2016 election and, just as importantly, working to begin litigating the 2020 presidential election. But we had an opportunity for the American people to speak. They did. They voted in 2016, and they wanted judges and justices who will be faithful to the Constitution. That's why I'm confident at the end of what Shakespeare would describe as a lot of sound and fury signifying nothing, I am confident that Judge Kavanaugh will become Justice Kavanaugh and will be confirmed to the United States Supreme Court. Thank you, Mr. Chairman.
Okay. We're going to take a break now, and wait a minute. We're going to take a break now, and 30 minutes is what the Democrats would like to have, so we will return at 1:17, and Gorsuch returned about 10 minutes later than that, so be on time, please.
Not Gorsuch. You said Gorsuch.
Yeah. Well.
All right, guys, so as the senators take this break, we're going to roll it back into the newsroom here and give you a little background on what you're watching. We're going to start our top stories of the day here with a little more information about Democrats versus Judge Kavanaugh and what we can expect for this week. These confirmation hearings are expected to last throughout the week, and of course, today is just day one of those. So we're going to roll through a couple stories here for you, and as always, thanks for watching on our stream today. Pretty much dedicated to this today, as looks like they're taking a quick 30-minute break. So we'll show you some of the stories, and then we'll be back with our look inside the Senate Judiciary Committee for more of this hearing coming up shortly. Take a look at these stories, give you a little background on what's been happening, and then some other top stories that have been happening across the nation and the world from today and this weekend. We're also hearing a little bit of breaking news. Cindy McCain, wife of former Senator John McCain, whose funeral was this weekend, has announced, as well as other outlets have announced, that former Senator Jon Kyl, old friend of Cindy and John McCain, will be replacing Senator McCain in that spot, at least until 2020, when there will be a special election to see who might fill John McCain's spot, if not continuing on with Senator Kyl. And then that next person or himself will continue on through what would have been McCain's term through 2022.
Nominated to the Supreme Court, that progressives rallied there with an unmistakable directive to Senate Democrats.
I have one message for every senator. The keys to our future and our freedoms are in your hands.
The word went out across the progressive world. $5 million spent on attack ads.
Call your senators and tell them to oppose Trump's extreme nominee. Stop Brett Kavanaugh.
But progressives faced major obstacles, a change to Senate rules that then Senate Majority Leader Harry Reid set in motion, requiring only a simple majority vote for the confirmation of administration appointees and lower court judges. When the Senate changed hands, Majority Leader Mitch McConnell upped the ante, applying that change to Supreme Court nominees, too. Lacking the votes, Democrats hoped for Republican defections, but fence-sitters Rand Paul, Susan Collins, and Lisa Murkowski all signaled their support for Kavanaugh, effectively dashing progressives' hopes. Those hopes were temporarily revived with the conviction of Paul Manafort and the plea deal of Trump lawyer Michael Cohen.
We should be pushing to postpone the Kavanaugh hearing. This nomination is now tainted with illegality.
Hopes were revived again when Democrats accused the administration of withholding documents from Kavanaugh's years as a lawyer in the George W. Bush administration.
I think there's frustration that it looks like they're kind of just going to rubber stamp this through.
But the sheer volume of Kavanaugh's paper trail over 900,000 pages as White House Associate Counsel, and millions of other documents from his years on the D.C. Circuit Court of Appeals overwhelmed that Democrat argument. A close examination of all that would have delayed his nomination well past the midterms. And that's a time frame that Senate Republicans simply wouldn't tolerate. So, the hearings get underway on Tuesday. Senate Majority Leader Mitch McConnell says that he fully expects Kavanaugh to be seated on the high court bench come their next term, October 1st. At the Supreme Court, Doug McKelway, Fox News.
Republicans have numbers on their side, but Democrats hope to at least score some points on Kavanaugh, even if they can't outright block his nomination, and this could get ugly. At this point, Brett Kavanaugh must be bracing for battle. He has spent some time on Capitol Hill, but nothing like what will happen in this hearing room today, and he will start by having to sit and listen.
Today, I think what we can expect are very long grandstanding style speeches by the senators looking for their literal 15 minutes of fame on national TV.
Many Democrats this week plan to tear into Kavanaugh, pouring through tens of thousands of documents from his lengthy career, some of which just became available last night. Democratic Senate Leader Chuck Schumer has said that the hearings should be delayed, and he has concerns about the judge's views on executive powers.
Judge Kavanaugh's judicial philosophy incorporates an almost monarchical view of executive power and accountability, animated by a belief that our chief executive gets to play by a different set of rules.
Senate Judiciary Chairman Chuck Grassley says most Democrats have already made up their minds.
So the bottom line is, how much more do you need to know to vote no?
Ron Bonjean helped shepherd Neil Gorsuch, the last Supreme Court nominee, through this process. He says at this point, Kavanaugh has spent hours and hours preparing.
They set up a fake hearing room, and they have White House counsel, they have former clerks, former senators and current senators that come in and ask him the hardest questions to get him ready for those hearings, because it is arduous to sit there all day and be pounded with questions.
Now, at this point, Kavanaugh is likely to get enough Republican support to win confirmation, but this may put at least 3 or 4 Democrats from red states in a tough position. In Washington, Doug Luzader, Fox News.
Tropical Storm Gordon slammed southern Florida Monday, bringing whipping winds, heavy rain, and high surf. But the wild weather couldn't keep some beachgoers off the sand.
I came to get wet, so why run from the rain?
Meanwhile, the storm is making its way north through the Gulf of Mexico toward the coast, with landfall anticipated on Tuesday. And people are bracing for not only a possible direct hit, but the pounding rain, tropical storm force winds, dangerous storm surge, and flash flooding that will come.
You got a concern whenever there's a hurricane in the Gulf.
A group of volunteers known as the Louisiana Cajun Navy are setting up a staging area in New Orleans, so they are ready to help if the storm strikes.
Preparing for the worst, praying for the best at this point. Just prepared for everything. You know, we've got safety supplies, we've got food, water, drinks, boats ready to go out in that case of an emergency, and so we're just here to help.
On Monday, Louisiana's governor issued a state of emergency, and harbors along Mississippi's coast were placed under mandatory evacuation.
Maybe 3 to 5 inches of rain, so really the high tide and the storm surge is what we're worried about.
Gordon is not the only storm meteorologists are keeping their eyes on. Tropical storm Florence is churning out in the eastern Atlantic Ocean, and it's too early to tell how that storm will develop. In Los Angeles, Alicia Cunha, Fox News.
It's the second time in 2 months a U.S. service member apparently killed by the very same Afghan forces he was there to train. 6 U.S. troops have been killed in Afghanistan this year. In a statement announcing the latest casualty, the new head of U.S. forces in Afghanistan said, quote, "The sacrifice of our service member who volunteered for a mission to Afghanistan to protect his country is a tragic loss. Our duty now is to honor him, care for his family, and continue our mission."
That's a good copy.
A mission that has now stretched for nearly 2 decades. General Scott Miller becomes the 9th U.S. general in 17 years to lead all U.S. and allied forces in Afghanistan. Miller is the former head of Joint Special Operations Command, responsible for leading elite commando units such as Delta Force, SEAL Team 6, and the 75th Ranger Regiment. Today's apparent insider attack, when friend turns foe, comes just one day after Miller took command.
The world recognizes that Afghanistan cannot be a safe haven for terrorism. The world recognizes we cannot fail. I know this has been a long fight, and it has been generational. I understand the reason we're fighting, and I know why we're here. And I know terrorists seek safe haven.
A point echoed by Britain's defense minister on a recent visit to Afghanistan, as he warned of the ever-growing threat from ISIS.
We're seeing the terrorist groups operating here in Afghanistan, evidence of their links back not just to the United Kingdom, but to the whole of continental Europe.
Raising fears of another attack similar to last year's in Manchester, which killed 22 people attending an Ariana Grande concert. Today, 15,000 American troops remain, down from a high of over 100,000 during the Obama administration. Last week, the U.S. military's top officer said the reduction marked a new strategy put in place by President Trump a year ago.
I certainly don't expect that the current forces that we have in Afghanistan represents an enduring, large military commitment.
The Pentagon says it killed the head of ISIS in Afghanistan in a drone strike late last month, the third leader killed in the past 2 years. So far this year, the U.S. military has dropped more than 3,500 bombs in Afghanistan, more than double the amount over the same time a year ago, and more than 5 times the number in the first half of 2016. At the Pentagon, Lucas Tomlinson, Fox News.
Scottsdale Fire Department to the rescue. On Sunday, they saved the life of a puppy who got himself in a very tight situation.
It's a little more intense than the cat stuck in the tree, but luckily we had a good outcome.
The fire crew from Scottsdale's Engine 601 received a not-so-typical call on Sunday. A woman told them she could hear her 10-week-old puppy crying from her fireplace upstairs. Using their thermal imaging camera, the firefighters were able to spot the pup at the bottom.
Once we started looking at it, there was an 8x8 hole from the outside that the dog happened to get into, and it went about 2 feet back, and then the dog fell about 10 feet to the bottom of the basement in the chimney.
It took them about 15 minutes to bring the puppy to safety.
We had to break through the drywall, and then we used a sledgehammer and broke through. There was actually cinder blocks on the other side of the drywall. So we used the sledgehammer and busted a hole big enough and just reached in and grabbed the dog out.
This making for a happy pup with an even happier owner. Danielle Miller, Fox 10 News.
Iran is teaming up with Syria for what could be a major assault against the rebel forces. Mohammad Javad Zarif, Iran's foreign minister, is in Damascus today, meeting with Syrian President Bashar al-Assad. The two are hammering out details for this military operation against Syrian rebels in Idlib. UNICEF estimates that 1 million children are in danger should the assault take place, and the organization is requesting appropriate access to provide assistance.
If we're not given access anyway, there's going to be a very limited support we'll be able to give, because we won't be able to be there at the time where actually children need us then.
Idlib is home to an estimated 3 million civilians. Sprinkled amid those residents are nearly 30,000 rebel fighters, many of whom were bused to the city as part of a ceasefire brokered with the Syrian government. Later this week, Iranian President Hassan Rouhani is scheduled to meet with Russian President Vladimir Putin and Turkish President Tayyip Erdogan in Tehran to discuss whether or not there's any possible solutions to avoid the military option. The sides are divided on the fate of the Islamic militant group al-Nusra, many of whose members reside in Idlib.
This is the main problem about Idlib. In this area, which was marked a de-escalation zone, is that there must be separation between armed opposition, which is ready to hold dialogue with the government, and al-Nusra terrorists.
U.S. Secretary of State Mike Pompeo is pushing back against those comments, adding over the weekend that any chemical attack in Idlib would be met with a strong response by the United States and its allies. In Jerusalem, Trey Yingst, Fox News.
Neighbors heard cries for help coming from a storm drain.
It's just unbelievable. You can't believe something like that's happening.
Police say a 15-year-old boy was sucked inside this drain pipe around 7 Friday night. It happened at Tamarisk Parkway and Melissa Drive off of North Hurstbourne Parkway. Neighbors say the boy was playing in his backyard when he slipped and was swept away.
It just happened in a blink of an eye.
The boy traveled through the drain underground and was pushed out into a yard down the block. He was found unconscious. He wasn't breathing and was rushed to Norton Children's Hospital. Trinity High School says he's a sophomore student. Letters of support are taped to his front door.
Everybody wants to know how they can help, how he's doing, and just seeing what we can do to support Mom in the meantime.
The culvert runs behind Michelle Stack's home. She says heavy rain fills it with feet of water quickly, gushing into the drain pipe, creating a safety hazard with no grate to block the opening.
It's something that needs to be looked at. Obviously, it's an issue, so we need to figure out what ways we can keep something like this from ever happening again.
Thousands of veterans were exposed to dangerous chemicals from burn pits, and many now say that they feel abandoned by the VA. I sat down with retired General David Petraeus. He recalls what these troops were dealing with while deployed during the wars in Iraq and Afghanistan, and what it was like seeing these burn pits firsthand among the many challenges he faced at the time. Take a listen. In 2007, General David Petraeus took command of the coalition forces in Iraq. To defeat the enemy, he launched a robust counterinsurgency campaign. But there was another threat: exposure to burn pits.
At that time, we weren't worried about burn pits. We were worried about just getting enough water for our troops in the really hot summer. We were looking forward to the time where we might get some real food.
The general also recalls how burn pits were used on military bases to crudely incinerate everything from trash to medical waste, and early in the war, even human waste. As you and I both know, burn pits were used to dispose of things like chemical solvents, human waste, medical waste, all kinds of things were basically thrown into these. It sounds like you were very aware of this while you were in command, and it was just something that had to be done.
Well, it was something that had to be done for a long period of time, but at a certain point, it set in that perhaps there's a better way of doing it. And so again, a number of us surfaced these issues. And incinerators were actually brought in some cases. And then there were even problems just getting incinerators to work.
I know that you're aware of the huge number of veterans who believe that after being exposed to burn pits, they became sick. Many of their claims have been denied by the VA. A lot of them said the same thing, that they don't regret the service they did for our country, but now they feel like they're being abandoned by the government. So what should be done to address these veterans' concerns now?
Well, we should meet our obligation to our veterans in this and many other cases as well. It's an issue of trying to determine with some degree of scientific rigor, was there an effect because of the exposure to the smoke from the burn pits? If so, again, what are the symptoms of that? What can we do now to mitigate the risk of what could transpire from this?
General Petraeus has thrown his support behind the campaign to improve assistance for our veterans. In July, he sent a letter to Congress urging them to back the Burn Pits Accountability Act, a recently introduced bipartisan bill. He writes, quote, "I know that you share the sense of obligation that virtually all Americans have to those who have stepped forward at a time of war." In New York, Leah Gabriel, Fox News.
So a variety there of military stories for you guys on this Tuesday, September 4th. We're going through some of the top stories from the weekend and today. Before we get back to this scene, right here on Capitol Hill, they are on a 30-minute break and they'll be continuing shortly. So if you're jumping on with us for this Senate Judiciary Committee hearing for SCOTUS nominee Brett Kavanaugh, that's coming up in a little bit shortly. So that is what we're kind of focusing on today. This hearing process is a multi-day process. They're going to be going through a lot of sitting down, opening statements, and then of course question and answer, and then some witnesses as well. So it is a multi-day process. It'll go on throughout the week, and we're expecting it could get a little ugly in there. We don't quite know, but we've already seen it become a little bit dramatic this morning with protesters and the like. And And Brett Kavanaugh is expected to be asked about some hot button issues like abortion and healthcare and executive power, of course, of the the executive branch. So this all to come. You can see that the room has emptied out and they're filing back in shortly. We'll make sure we hit that at the top when they come back in. So stay on with us for more of that live coverage of this Senate hearing, this questioning, or rather it's been opening statements for now on day one of these hearings. On now to a couple more top stories from today.
Crews in Brazil attack a raging fire, trying desperately to save a 200-year-old museum. Flames began Sunday night after it closed and quickly ripped through the National Museum in Rio. By daylight, the fire was mostly out, though firefighters could be seen dousing the occasional flare-up. Among the museum's 20 million items, the Western Hemisphere's oldest human skull, a meteorite from the 1700s, and the first fossils ever found in the country. Tens of thousands of other relics specifically relate to Brazil's history, prompting one official to call the fire, quote, a lobotomy of the Brazilian memory.
We have to go through this period of mourning, but we have to think, what now? Brazil can't lose its history.
For many locals, the National Museum is more than just a place to store artifacts. It's a source of pride now reduced to a smoldering shell.
I just saw a piece of my history, the history of my country becoming ashes. It has no price. I'm devastated.
In a statement, Brazil's president says, quote, 200 years of work, investigation, and knowledge have been lost. But he also says they've received pledges of financial backing. Several public and private banks, a mining company, and an oil company plan to form a network of economic support to help restore the museum. The museum's dilapidated state had employees worried about the risk of something like this happening. Officials even trained workers on how to minimize the fire risk. Jeff Paul, Fox News.
I realize what an important decision this is, and that there is no replacing Senator John McCain. But the law requires me to do it, and the people of Arizona deserve representation in the U.S. Senate. It's a decision that I made with careful and thoughtful deliberation. As you can imagine, I received a lot of advice from people about this selection, most of it unsolicited. However, the best piece of advice that I received was from another governor, who said, just do the right thing. Pick the best possible person, regardless of politics. It was really good advice and clarifying advice, and it made my job easy. As I contemplated who could best serve our state in the U.S. Senate, I kept coming back to one name and one person, Jon Kyl. There is no one in Arizona with the stature of Senator Jon Kyl. He is a man without comparable peer. With nearly 2 decades experience in the Senate, serving alongside John McCain, Senator Kyl is prepared to hit the ground running. Over the last few months, Senator Kyl has been working closely with the White House on the Senate confirmation of President Donald Trump's nominee to the U.S. Supreme Court, Brett Kavanaugh. Now, Senator Kyl can cast a vote for Kavanaugh's confirmation. Senator Kyl is a beacon of integrity, highly regarded by people on both sides of the aisle, and able to work across party lines to get results. There's a reason he was considered one of the best senators in the country. It's because he was. He's an expert on the matters facing Arizona: water, land use, and issues facing our Native American communities. I want someone who can enter and lead on those conversations. For those reasons, I've asked Senator Jon Kyl to step forward once again in a spirit of service to aid our state and serve in the seat vacated by Arizona's most beloved adopted son, John McCain. People automatically assume that this appointment will serve through 2020. I haven't been able to get that assurance from Senator Kyl yet. What I have gotten is a commitment to serve Arizona through at least this session of Congress, and it's my hope that he serves longer. There's far too much work before the Senate, work that is important and consequential to our state and our nation, work that demands immediate attention. It's not the time for newcomers, and now is not the time for on-the-job training. Arizona needs someone who can hit the ground running on day one, and that's Jon Kyl. The fact is, every single day that Jon Kyl represents Arizona in the United States Senate is a day when our state is being well served. At the memorial here in the state capitol last week, Senator Kyl spoke of how Senator McCain always put the interests of Arizona and America before all else. Senator Kyl has done the same throughout his own service to our state and nation, and will do so again. Lastly, I want to thank Carol Kyl. She's been so kind and giving and selfless, and we so sincerely appreciate her. Thank you, Carol. No question, these are difficult circumstances, but we are blessed to have the leadership and statesmanship of Jon Kyl as we come together and move forward. Thank you.
Good morning. I am grateful for Governor Ducey's confidence in me and honored to accept this appointment. We're all saddened by the circumstances that required the appointment and appreciate that there was only one John McCain. John and I served the people of Arizona together for nearly 20 years. And in that spirit, along with Senator Flake, I will do my best to assure that Arizonans continue to be well represented in the U.S. Senate. The governor asked me to serve for the remainder of the term, and he's made some very convincing points. I've committed to serving at least through the second session of the 115th Congress. I do know I will not seek this seat in 2020 nor any other office in the future. I'm accepting this appointment to fill the seat vacated by the passing of my dear friend because of my sense of duty to the state I love and the institution of the Senate in which I served for 18 years, and because the governor asked for my help, and because I'm putting my country first, just as this seat's previous occupant did every single day for more than 30 years. For now, there is much unfinished business on the Senate's calendar, including confirmation of President Trump's nominees to judicial and executive branch positions. I look forward to going to Washington and getting to work. Thank you, Governor.
We'll take a few questions. Well, let me start off with the obvious one, Governor, and no offense, I've known the good senator since he was working for the Queen's Chamber. There was some comment that Mr. McCain was looking perhaps for a Latina woman, and we get, God help us, you and I, another old white guy. Tell me about that.
Howie, I wanted to pick the best possible person, regardless of politics. There is big work to be done in the United States Senate. No one in the state of Arizona has the stature of Jon Kyl. I asked, and I'm grateful that he accepted.
Senator Kyl, please, why couldn't you commit to serve past the end of the year? And does your lobbying work that you've been doing for a few years now, does that in any way impede your ability to serve in the Senate?
The answer to the second question is no. And the reason that I did not want to commit beyond the end of this congressional session is because when I left the Senate almost 6 years ago, I had no intention of returning. I needed to be with my family, to come back to Arizona more and to be at their side. So in that spirit, I'm willing to serve certainly through the end of this session, at least, in order to make sure that the business that is currently ongoing is taken care of, but I don't want to make a commitment beyond that.
Governor Ducey, should Senator Kyl step down before 2020, one, who do you think you would appoint then? Or two, would you leave the seat open until 2020?
Like I've said, I'm hoping that the senator will consider serving longer. I'll fulfill my responsibilities as they come due. Right now, Senator Kyl is going to be heading to Sky Harbor Airport to fly back to Washington, D.C. We're working with our Secretary of State and the Secretary of the Senate and Leader McConnell to have Senator Jon Kyl sworn in to the United States Senate to complete the work of this Congress.
We have a few more questions left. Let's do Dennis, Melissa, and then Yvonne.
And Governor, just to follow up on if Senator Kyl does step down at the end of the year, that seat would be open. You'd have to make another appointment. Would you appoint yourself?
I've been clear on that from the beginning. That's not going to happen. I am not in the universe of potentials for this. I love the job that I have, and I want to retain it. When I actually considered entering public life, I went and visited with Senator Kyl at the time and told him I was thinking of getting involved in public service. And the first question he asked me was, do you have an executive personality or a legislative personality? And I knew the answer immediately. I said an executive personality, and he said, then don't consider Congress. And I'm going to stick right here.
Governor, you said that you wanted to make this decision regardless of politics, but with all due respect, Senator Kyl has been working with the White House in an inherently political process of the Kavanaugh appointment. I don't understand how you can square this as a non-politicized appointment when he is someone who's been involved in a political process very recently.
I think it is in picking the best possible person, the person who has the experience, that has done the job and can soothe the citizens in terms of what they can accomplish. Jon Kyl has a record. He's worked across the aisle, and he has been lauded by both sides of the aisle, and he's going to do a good job for the state of Arizona.
So you're not just picking him because he's going to vote for Kavanaugh?
I'm picking him because he's the best possible person.
Can you give us a sense of the conversations that you had with Cindy McCain and other people close to the late Senator John McCain's family? I mean, clearly you have taken their feelings and their opinions into consideration. Can you take us behind the scenes and give us a sense of what those conversations have looked like and what their reaction to your selection has been?
Well, of course, I think you saw last week was all about honoring Senator John McCain, of comforting the family and the citizens of Arizona. I do want to hold those conversations in confidence, but I want you to know that the conversation that I had with Cindy this morning was incredibly positive, and I would point you to her own social media feed as to her response to this decision.
Last question is...
Yeah, Senator, how would you describe your relationship with President Trump?
Well, I don't really have a relationship with President Trump. I have only met him on one occasion several months ago. But it is my honor to be helping on the Kavanaugh nomination. I believe in Judge Kavanaugh. And in that capacity, I've been able to support not just Judge Kavanaugh, but the administration, and I think the proper administration of justice.
Senator, in the past you've described his style as boorish and as his own worst enemy. Do you still stand by that? I
think sometimes his desire to jump into the middle of a fight or maybe even create a fight, by the way, that reminds me of somebody, but sometimes that can be detrimental to what he's trying to achieve. And that's what I said, and I stand by that comment.
Thank you.
Did you just compare the president to John McCain?
I will direct everyone else to the press release that we just issued. Thank you.
Thank you.
Would be less than what it is. And it seems to me that that's something that I hope somebody will take into consideration. Probably won't, but at least I said my piece. Then also, several senators have brought up about the 6% and the 99% and things like that that I thought I ought to clear up, because I could say myself that when I first started finding out how much paper Judge Kavanaugh had on his record, I mean, for his background, I started talking about 1 million pages. And then when we finally get 488,000, then I could say, well, I got about 48% of what we ought to have. But there's a good explanation why we don't have it. So I want to read. Some of my colleagues keep saying that we have only 6% of Judge Kavanaugh's White House records, but that 99% of Justice Kagan's White House records were made public before the hearing. This is fuzzy math. My colleagues calibrate their phony 6% figure on two inaccurate numbers. First, their 6% figure counts the estimated page count by career archivists at the National Archives based upon their historical practice before the unprocessed emails and attachments are actually reviewed. When Judge Kavanaugh's White House emails that we've received, the actual number of pages ended up being significantly less than the number the National Archives estimated before the actual review. One reason is because we were able to use technology to cull out the exact duplicate emails. Instead of having to read 13 times an email that Judge Kavanaugh sent to 12 White House colleagues, we only had to read the email once. Second, the 6% figure counts millions and millions of pages of irrelevant staff secretary documents that we never ever requested or needed. More importantly, we received 100% of the documents we requested from Judge Kavanaugh's time as an executive branch lawyer. And while we may have received 99% of Justice Kagan's White House records, we received 0 records from her most relevant legal service as a Solicitor General, the federal government's top Supreme Court advocate. We received much less than 99% of her records as a lawyer. And we didn't receive 60,000 emails from Justice Kagan, so 99% is an overestimate. And even though we never received them, Justice Kagan's Solicitor General records were much more needed at the time because Kagan was a blank slate as a judge. Instead, unlike Judge Kavanaugh, with his 12 years of judicial service and over 10,000 pages of judicial writings on the nation's most important federal circuit court, Justice Kagan had 0 years of judicial service and 0 pages of judicial writing before her appointment to the highest court. Senator Klobuchar.
Well, thank you, Mr. Chairman. And before I begin my opening statement, I just wanted to respond to just a few things. One, none of that takes away from the fact that 42,000 documents were dumped on us last night. And I don't think anyone would go to trial and allow a trial to go forward or allow a case to go forward if one side got 42,000 documents the night before and the other side, and you can't simply review them. As pointed out by Senator Whitehouse, you'd have to review 7,000 documents every hour. That happened last night.
Let me respond without taking time away from you.
Thank you.
You Democrats got exactly the same amount of money we did to do the work, the massive amount of work we had to do. And we got it done at 11 o'clock last night.
The point is that no one could prepare and review 42,000 documents in one evening. We know that, no matter how much coffee you drink. And the second point is that it is true that executive privilege has never been invoked before to block the release of presidential records during this to the Senate during a confirmation hearing. So I will begin my opening statement, but those are 2 points I don't believe are refuted. So.
Okay, well, I'll refute it from this standpoint. There were 5,000 documents, 42,000 pages.
Okay.
Proceed.
Thank you. Welcome, Judge Kavanaugh. We welcome your family as well. On its face, this may look like a normal confirmation hearing. It has all the trappings, all of us up here, all of the cameras out there, the statements, the questions, all of it looks normal. But this is not a normal confirmation hearing. First, as we have debated this morning, we are being asked to give advice and consent when the administration has not consented to give us over 100,000 documents, all of which detail a critical part of the judge's career, the time he spent in the White House. And in addition, the majority party has not consented to make 189,000 of the documents we do have public. As a former prosecutor, I know that no lawyer goes to court without reviewing the evidence and record. I know, and I know you know, Judge Kavanaugh, that a good judge would not decide a case with only 7% of the key documents. A good judge would not allow a case to move forward if one side dropped 42,000 pages of documents on the other side the night before the case started. And yet, that is where we are today. This isn't normal. It's an abdication of the role of the Senate and a disservice to the American people, and it is our duty to speak out. Secondly, this nomination comes before us at a time when we are witnessing seismic shifts in our democracy. Foundational elements of our government, including the rule of law, have been challenged and undermined. Today, our democracy faces threats that we never would have believed would be occurring not that long ago. Our intelligence agencies agree that a foreign adversary attempted to interfere in our most recent election, and it's happening again. In the words of the President's Director of National Intelligence, the lights are blinking red. There is an extensive ongoing investigation by a special counsel. The President's private lawyer and campaign chairman have been found guilty of multiple federal crimes. The man appointed as special counsel in this investigation, a man who has served with distinction under presidents from both parties, has been under siege. The dedicated public servants who work in our Justice Department, including the Attorney General and the FBI, have been subjected to repeated threats and have had their work politicized and their motives questioned. In fact, just this past weekend, federal law enforcement was called out, was rebuked by the President of the United States for simply doing their jobs, for prosecuting 2 white-collar defendants, one for insider trading, one for campaign theft. Why? Because the defendants were personal friends and campaign supporters of the President of the United States. As a former prosecutor, as someone who has seen federal law enforcement do their jobs, this is abhorrent to me. So no, this is not normal. And the last branch, the third branch of government, our courts and individual judges, have been under assault, not just by a solitary disappointed litigant, but by the President of the United States. Our democracy is on trial. And for the pillars of our democracy and our Constitution to weather this storm, our nation's highest court must serve as a ballast in these turbulent times. Our very institutions and those nominated to protect these institutions must be fair, impartial, and unwavering in their commitment to truth and justice. So today we will begin a hearing in which it is our duty to carry on the American constitutional tradition that John Adams stood up for many centuries ago. And that is to be, in his words, a government of laws and not men. To me, that means figuring out what your views are, Judge, on whether a president is above the law. It is a simple concept we learned in grade school, that no one is above the law. So I think it's a good place to start. There were many highly credentialed nominees like yourself that could have been sitting before us today. But to my colleagues, what concerns me is that during this critical juncture in history, the president has handpicked a nominee to the court with the most expansive view of presidential power possible, a nominee who has actually written that the president, on his own, can declare laws unconstitutional. Of course, we are very pleased when a judge submits an article to the University of Minnesota Law Review, and even more so when that article receives so much national attention. But the article you wrote that I'm referring to, Judge, raises many troubling questions. Should a sitting president really never be subject to an investigation? Should a sitting president never be questioned by a special counsel? Should a president really be given total authority to remove a special counsel? In addition to the article, there are other pieces of this puzzle which demonstrate that the nominee before us has an incredibly broad view of the president's executive power. Judge Kavanaugh, you wrote, for example, in 7 Sky v. Holder, that a president can disregard a law passed by Congress if he deems it to be unconstitutional, even if a court has upheld it. What would that mean when it comes to laws protecting the special counsel? What would that mean when it comes to women's health care? The days of the divine rights of kings ended with the Magna Carta in 1215. And centuries later, in the wake of the American Revolution, a check on the executive was a major foundation of the United States Constitution. For it was James Madison, who may not have had a musical named after him, but was a top scholar of his time, who wrote in Federalist 47, "The accumulation of all powers, legislative, executive, and judiciary, in the same hands may justly be pronounced the very definition of tyranny." So what does that warning mean in real-life terms today? Here's one example. It means whether people like Kelly Gregory, an Air Force veteran, mother, and business owner who is here from Tennessee and who is living with stage 4 breast cancer, can afford medical treatment. At a time when the administration is arguing that protections to ensure people with pre-existing conditions can't be kicked off their health insurance are unconstitutional, we cannot and should not confirm a justice who believes the president's views alone carry the day. One opinion I plan to ask about: when judges appointed by presidents of both parties joined in upholding the Consumer Financial Protection Bureau, you, Judge, dissented. Your dissent concluded that the Bureau, an agency which has served us well in bringing back over $12 billion to consumers for fraud from credit cards to loans to mortgages, was unconstitutional. Or in another case, you wrote a dissent against the rules that protect net neutrality, rules that help all citizens and small businesses have an even playing field when it comes to accessing the internet. Another example that seems mired in legalese but is critical for Americans: antitrust law. In recent years, a conservative majority on the Supreme Court has made it harder and harder to enforce the nation's antitrust laws, ruling in favor of consolidation and market dominance. Yet 2 of Judge Kavanaugh's major antitrust opinions suggest that he would push the court even further down this pro-merger path. We should have more competition and not less. Now, to go from my specific concerns and end on a higher plane. All of the attacks on the rule of law in our justice system over the past year have made me, and I would guess some of my other colleagues on this committee, pause and think many times about why I decided to come to the Senate and get on this committee, and much further back, why I even decided to go into law in the first place. Now, I will tell you that not many girls in my high school class said they dreamed of being a lawyer. We had no lawyers in my family, and my parents were the first in their families to go to college. But somehow my dad convinced me to spend a morning sitting in a courtroom watching a state court district judge handle a routine calendar of criminal cases. The judge took pleas, listened to arguments, and handed out misdemeanor sentences. It was certainly nothing glamorous like the work for the job you've been nominated for, Judge, but it was important just the same. I realized that morning that behind every single case, there was a story and there was a person, no matter how small. Each and every decision the judge made that day affected that person's life. And I noticed how often he had to make gut decisions and had to take account of what his decisions would mean for that person and his or her family. This week, I remembered that day, and I remembered I had written an essay about it at the ripe old age of 17. I went back and looked at what I had said. It is something that I still believe today, and that is that to be part of an imperfect system, to have a chance to better that system, was and is a cause worth fighting for, a job worth doing. Our government is far from perfect, Judge, nor is our legal system, but we are at a crossroads in our nation's history where we must make a choice. Are we going to dedicate ourselves to improving our democracy, improving our justice system, or not? The question we are being asked to address in this hearing, among others, is whether this judge, at this time in our history, will administer the law with equal justice as it applies to all citizens, regardless of if they live in a poor neighborhood or a rich neighborhood, or if they live in a small house or the White House. Our country needs a Supreme Court justice who will better our legal system, a justice who will serve as a check and balance on the other branches of government, who will stand up for the rule of law without consideration of politics or partisanship, who will uphold our Constitution without fear or favor, and who will work for the betterment of the great American experiment in democracy. That is what this hearing is about. Thank you.
Senator Sasse.
Thank you, Mr. Chairman. We need to get to Judge Kavanaugh, but I really want to riff with Amy for a while. Senator Klobuchar, you did Madison, Lin-Manuel Miranda, the Magna Carta, and your dad taking you to court. Well done.
That.
I had all that on my bingo card. I have little kids, and I've taken my 2 little girls to court a few times too, mostly to juvie, just to scare them straight, not to turn them into attorneys. But that's
Who said that that wasn't what my dad was doing, Senator Sasse?
That was wisdom in Minnesota. Congratulations, Judge, on your nomination. Ashley, congratulations and condolences. This process has to stink. I'm glad your daughters could get out of the room, and I hope they still get the free day from school. Let's do some good news, bad news. The bad news first. Judge, since your nomination in July, you've been accused of hating women, hating children, hating clean air, wanting dirty water. You've been declared a quote-unquote existential threat to our nation. Alumni of Yale Law School incensed that faculty members at your alma mater praised your selection, wrote a public letter to the school saying, quote, "People will die if Brett Kavanaugh is confirmed." This drivel is patently absurd, and I worry that we're going to hear more of it over the next few days. But the good news is, it is absurd, and the American people don't believe any of it. This stuff isn't about Brett Kavanaugh when screamers say this stuff for cable TV news. The people who know you better, not those who are trying to get on TV, they tell a completely different story about who Brett Kavanaugh is. You've earned high praise from the many lawyers, both right and left, who've appeared before you during your 12 years on the DC circuit, and those who've had you as a professor at Yale Law and at Harvard Law. People in legal circles invariably applaud your mind, your work, your temperament, your collegiality. That's who Brett Kavanaugh is. And to quote Lisa Blatt, a Supreme Court attorney from the left who's known you for a decade, quote, "Sometimes a superstar is just a superstar, and that's the case with this judge. The Senate should confirm him," close quote. It's pretty obvious to most people going about their work today that the deranged comments actually don't have anything to do with you. So we should figure out, why do we talk like this about Supreme Court nominations now? There's a bunch that's atypical in the last 19, 20 months in America. Senator Klobuchar's right. The comments from the White House yesterday about trying to politicize the Department of Justice, they were wrong and they should be condemned. And my guess is Brett Kavanaugh would condemn them. But really, the reason these hearings don't work is not because of Donald Trump. It's not because of anything the last 20 months. These confirmation hearings haven't worked for 31 years in America. People are going to pretend that Americans have no historical memory, and supposedly there haven't been screaming protesters saying women are going to die at every hearing for decades. But this has been happening since Robert Bork. This is a 31-year tradition. There's nothing really new the last 18 months. So The fact that the hysteria has nothing to do with you means that we should ask, what's the hysteria coming from? The hysteria around Supreme Court confirmation hearings is coming from the fact that we have a fundamental misunderstanding of the role of the Supreme Court in American life now. Our political commentary talks about the Supreme Court like there are people wearing red and blue jerseys. That's a really dangerous thing. And by the way, if they have red and blue jerseys, I would welcome my colleagues to introduce the legislation that ends lifetime tenure for the judiciary. Because if they're just politicians, then the people should have power and they shouldn't have lifetime appointments. So until you introduce that legislation, I don't believe you really want the Supreme Court to be a politicized body, though that's the way we constantly talk about it now. We can and we should do better than this. It's predictable that every confirmation hearing now is going to be overblown, politicized circus. And it's because we've accepted a new theory about how our three branches of government should work, and in particular, how the judiciary should work. What Supreme Court confirmation hearings should be about is an opportunity to go back and do schoolhouse rock civics for our kids. We should be talking about how a bill becomes a law and what the job of Article 2 is and what the job of Article 3 is. So let's try just a little bit. How did we get here and how can we fix it? I want to make just 4 brief points. Number 1, in our system, the legislative branch is supposed to be the center of our politics. Number 2, it's not. Why not? Because for the last century, and increasing by the decade right now, more and more legislative authority is delegated to the executive branch every year. Both parties do it. The legislature is impotent, the legislature is weak, and most people here want their jobs more than they really want to do legislative work, and so they punt most of the work to the next branch. Third consequence is that this transfer of power means the people yearn for a place where politics can actually be done. And when we don't do a lot of big actual political debating here, we transfer it to the Supreme Court. And that's why the Supreme Court is increasingly a substitute political battleground in America. It is not healthy, but it is what happens, and it's something that our founders wouldn't be able to make any sense of. And fourth and finally, we badly need to restore the proper duties and the balance of power from our constitutional system. So point 1, the legislative branch is supposed to be the locus of our politics, properly understood. Since we're here in this room today, because this is a Supreme Court confirmation hearing, we're tempted to start with Article 3. But really, we need Article 3 is the part of the Constitution that sets up the judiciary. We really should be starting with Article 1, which is us. What is the legislature's job? The Constitution's drafters began with the legislature. These are equal branches, but Article 1 comes first for a reason. And that's because policymaking is supposed to be done in the body that makes laws. That means that this is supposed to be the institution dedicated to political fights. If we see lots and lots of protests in front of the Supreme Court, that's a pretty good litmus test barometer of the fact that our republic isn't healthy. Because people shouldn't be thinking they are protesting in front of the Supreme Court. They should be protesting in front of this body. The legislature is designed to be controversial, noisy, sometimes even rowdy, because making laws means we have to hash out the reality that we don't all agree. Government is about power. Government is not just another word for things we do together. The reason we have limited government in America is because we believe in freedom. We believe in souls. We believe in persuasion. We believe in love. And those things aren't done by power. But the government acts by power. And since the government acts by power, we should be reticent to use power. And so it means when you differ about power, you have to have a debate. And this institution is supposed to be dedicated to debate and should be based on the premise that we know since we don't all agree, we should try to constrain that power just a little bit, but then we should fight about it and have a vote in front of the American people. And then what happens? The people get to decide whether they want to hire us or fire us. They don't have to hire us again. This body is the political branch where policymaking fights should happen. And if we are the easiest people to fire, it means the only way the people can maintain power in our system is if almost all the politicized decisions happen here, not in Article 2 or Article 3. So that brings us to a second point. How do we get to a place where the legislature decided to give away its power? We've been doing it for a long time. Over the course of the last century, but especially since the 1930s and then ramping up since the 1960s, a whole lot of the responsibility in this body has been kicked to a bunch of alphabet soup bureaucracies. All the acronyms that people know about their government or don't know about their government are the places where most actual policy making kind of in a way, lawmaking is happening right now. This is not what Schoolhouse Rock says. There's no verse of Schoolhouse Rock that says give a whole bunch of power to the alphabet soup agencies and let them decide what the governance decision should be for the people, because the people don't have any way to fire the bureaucrats. And so what we mostly do around this body is not pass laws. What we mostly do is decide to give permission to the secretary or the administrator of bureaucracy X, Y, or Z to make law-like regulations. That's mostly what we do here. We go home and we pretend we make laws. No, we don't. We write giant pieces of legislation, 1,200 pages, 1,500 pages long, that people haven't read, filled with all these terms that are undefined, and we say the secretary of such and such shall promulgate rules that do the rest of our dang jobs. That's why there's so many fights about the executive branch and about the judiciary, because this body rarely finishes its work. And the House is even worse. I don't really believe that. It just seemed like you needed to try to unite us in some way. So I admit that there are rational arguments that one could make for this new system. The Congress can't manage all the nitty-gritty details of everything about modern government, and this system tries to give power and control to experts in their fields, where most of us in Congress don't know much of anything, or about technical matters for sure, but you could also impugn our wisdom if you want. But when you're talking about technical, complicated matters, it's true that the Congress would have a hard time sorting out every final dot and tittle about every detail. But the real reason at the end of the day that this institution punts most of its power to executive branch agencies is because it's a convenient way for legislators to have to be able to avoid taking responsibility for controversial and often unpopular decisions. If people want to get reelected over and over again, and that's your highest goal, if your biggest long-term thought around here is about your own incumbency, then actually giving away your power is a pretty good strategy. It's not a very good life, but it's a pretty good strategy for incumbency. And so at the end of the day, a lot of the power delegation that happens from this branch is because the Congress has decided to self-neuter. Well, guess what? The important thing isn't whether or not the Congress has lame jobs. The important thing is that when the Congress neuters itself and gives power to an unaccountable fourth branch of government, it means the people are cut out of the process. There's nobody in Nebraska, there's nobody in Minnesota or Delaware who elected the Deputy Assistant Administrator of Plant Quarantine at the USDA. And yet if the Deputy Assistant Administrator of Plant Quarantine does something to make Nebraskans' lives really difficult, which happens to farmers and ranchers in Nebraska, who do they protest to? Where do they go? How do they navigate the complexity and the thicket of all the lobbyists in this town to do executive agency lobbying? They can't. And so what happens is they don't have any ability to speak out and to fire people through an election. And so ultimately, when the Congress is neutered, when the administrative state grows, when there is this fourth branch of government, it makes it harder and harder for the concerns of citizens to be represented and articulated by people that the people know that they have power over. All the power right now, or almost all the power right now, happens off stage. And that leaves a lot of people wondering who's looking out for me. And that brings us to the third point. The Supreme Court becomes our substitute political battleground. It's only 9 people. You can know them, you can demonize them, you can try to make them messiahs, but ultimately, because people can't navigate their way through the bureaucracy, they turn to the Supreme Court looking for politics. And knowing that our elected officials no longer care enough to do the hard work of reasoning through the places where we differ and deciding to shroud our power at times, it means that we look for 9 justices to be super legislators. We look for 9 justices to try to right the wrongs from other places in the process. When people talk about wanting to have empathy from their justices, this is what they're talking about. They're talking about trying to make the justices do something that the Congress refuses to do as it constantly abdicates its responsibility. The hyperventilating that we see in this process and the way that today's hearing started with 90 minutes of theatrics that are pre-planned with certain members of the other side here, it shows us a system that is wildly out of whack. And thus a fourth and final point. The solution here is not to try to find judges who will be policymakers. The solution is not to try to turn the Supreme Court into an election battle for TV. The solution is to restore a proper constitutional order with a balance of powers. We need Schoolhouse Rock back. We need a Congress that writes laws and then stands before the people and suffers the consequences and gets to go back to our own Mount Vernon if that's what the electors decide. We need an executive branch that has a humble view of its job as enforcing the law, not trying to write laws in the Congress's absence. And we need a judiciary that tries to apply written laws to facts and cases that are actually before it. This is the elegant and the fair process that the founders created. It's the process where the people who are elected, 2 and 6 years in this institution, 4 years in the executive branch, can be fired because the justices and the judges, the men and women who serve America's people by wearing black robes, they're insulated from politics. This is why we talk about an independent judiciary. This is why they wear robes. This is why we shouldn't talk about Republican and Democratic judges and justices. This is why we say justice is blind. This is why we give judges lifetime tenure. And this is why this is the last job interview Brett Kavanaugh will ever have, because he's going to a job where he's not supposed to be a super legislator. So the question before us today is not what does Brett Kavanaugh think 11 years ago on some policy matter. The question before us is whether or not he has the temperament and the character to take his policy views and his political preferences and put them in a box marked irrelevant and set it aside every morning when he puts on the black robe. The question is, does he have the character and temperament to do that? If you don't think he does, vote no. But if you think he does, stop the charades. Because at the end of the day, I think all of us know that Brett Kavanaugh understands his job isn't to rewrite laws as he wishes they were. He understands that he's not being interviewed to be a super legislator. He understands that his job isn't to seek popularity. His job is to be fair and dispassionate. It is not to exercise empathy. It is to follow written laws. Contrary to the onion-like smears that we hear outside, Judge Kavanaugh doesn't hate women and children. Judge Kavanaugh doesn't lust after dirty water and stinky air. No, looking at his record, it seems to me that what he actually dislikes are legislators that are too lazy and too risk-averse to do our actual jobs. It seems to me that if you read his 300-plus opinions, what his opinions reveal to me is a dissatisfaction. I think he would argue a constitutionally compelled dissatisfaction with power-hungry executive branch bureaucrats doing our job when we fail to do it. And in this view, I think he's aligned with the founders. For our Constitution places power not in the hands of this city's bureaucracy, which can't be fired, but our Constitution places the policymaking power in the 535 of our hands because the voters can hire and fire us. And if the voters are going to retain their power, they need a legislature that's responsive to politics, not a judiciary that's responsive to politics. It seems to me that Judge Kavanaugh is ready to do his job. The question for us is whether we're ready to do our job. Thank you, Mr. Chairman.
Yeah. The example I always use to back up what Senator Sasse says about Congress not doing its job and delegating too much is the Obamacare legislation that was 2,700 pages, and there was 1,693 delegations of authority to bureaucrats to write regulations because Congress didn't know how to reorganize health care. Senator Coons.
Thank you, Mr. Chairman. Welcome, Judge Kavanaugh. Welcome to you and to your family and to your friends who are here. As you know well, we went to the same law school. We clerked in the same courthouse in Wilmington, Delaware. So I've known you and your reputation for nearly 30 years. And I know well that you have a reputation as a good friend, a good classmate, a good roommate, as a good husband and family man, that you've contributed to your community. I think we'll hear later today that you've even been a great youth basketball coach. But frankly, we're not here to consider you as the president of our neighborhood civic association or even to review whether you've been a great youth basketball coach. We're here to consider you for a lifetime appointment to the United States Supreme Court, where you will help shape the future of this country and have an impact on the lives of millions of Americans for literally decades to come. And to make that decision to exercise our constitutional role, we have to look closely at your decisions, your statements, your writings to understand how you might interpret our Constitution. The next justice will play a pivotal role in defining a wide range of critical issues, including the scope of the president's power and determining whether the president might be above the law. The next justice will impact essential rights enshrined in our modern understanding of the Constitution, including the right to privacy, rights to contraception, intimacy, abortion, marriage, the freedom to worship as we choose, the ability to participate in our democracy as full citizens, and the promise of equal protection. That's because the cases that come before the court aren't just academic or esoteric or theoretical.
They involve real people and have real and lasting consequences. With the stakes this high, I deeply regret the process that's gotten us to this point, the excesses and partisan gamesmanship of the last few years, and that history bears briefly repeating. When Justice Scalia passed in February of 2016, I called the White House and urged then President Obama to nominate a jurist who could gain support from both sides of the aisle and help build a strong center on the court. And he did just that when he nominated Merrick Garland, Chief Judge of the D.C. Circuit, whom I know you also admire. But my Republican colleagues refused to even meet with him, much less hold a hearing or a vote on his confirmation. During the 400 days that the majority refused to fill the Supreme Court vacancy, then President Trump also released a list of potential nominees to the court, a list compiled by two highly partisan organizations, the Federalist Society and the Heritage Foundation. And after our president was elected, he picked from that list and nominated Neil Gorsuch to the Supreme Court. When Judge Gorsuch testified before this very committee, he told us repeatedly how deeply he understood and respected precedent. He even cited a book on precedent he'd co-authored with you. But in his first 15 months of service, Justice Gorsuch has already voted to overrule at least 5 important Supreme Court precedents and to question many others. To name just one, given it was just Labor Day, Justice Gorsuch voted to gut public sector unions, overturning a 41-year-old precedent on which there were great reliance interests in impacting millions of workers across the country. My point is that Justice Gorsuch was confirmed to the court in one of the most concerningly partisan processes in Senate history, and only after the majority deployed the nuclear option to end the filibuster for Supreme Court nominations. This brings us, Judge, to today and your nomination. When Justice Kennedy announced his retirement, I once again called the White House and urged through White House counsel that President Trump consider selecting someone for the seat who could win broad support from both sides of the aisle. And Judge Kavanaugh, I'm concerned you may not be that nominee. Your record prior to joining the bench places you in the midst of some of the most pitched and partisan battles in our lifetimes, from Ken Starr's investigation of President Clinton to the 2000 election recount to the controversies of the Bush administration, including surveillance, torture, access to justice, and the culture wars. So, Judge, it's critical that this committee and the American people fully examine your record to understand what kind of justice you would be. And unfortunately, as we've all discussed at length here today, that's been rendered impossible. The majority has blocked access to millions of pages of documents from your service in a critical role in the White House. For the first time since Watergate, the nonpartisan National Archives has been cut out of the process for reviewing and producing your records. Senate Republicans have worked to keep committee confidential nearly 200,000 pages of documents so that the public can't view them and we can't question based on them. And your former deputies in charge of designating which documents this committee and the American people get to see. Not only that, but for the first time in our history, the president has invoked executive privilege to withhold more than 100,000 pages of documents on a Supreme Court nominee from the Judiciary Committee. This leads to a difficult but important question, which is what might President Trump or the majority be trying to hide? Mr. Chairman, I want to make an appeal to work together to restore the integrity of this committee. We are better than this process. We are better than proceeding with a nominee without engaging in a full and a transparent process. This committee is failing the American people by proceeding in this way, and I fully support the motions made by my colleagues earlier in this hearing and regret that we proceeded without observing the rules of this committee. That said, Judge Kavanaugh, I have reviewed the parts of your record that I've been able to access and what I've been able to see from available speeches, writings, and decisions, and I have to say it troubles me. While serving on the bench, you've dissented at a higher rate than any circuit judge elevated to the Supreme Court since 1980, and that includes Judge Bork. Your dissents reveal some views and positions that fall well outside the mainstream of legal thought. You've suggested, as has been referenced, that the president has the authority to refuse to enforce a law such as the Affordable Care Act were he to decide it was unconstitutional. You voted to strike down net neutrality rules, gun safety laws, the organization of the Consumer Financial Protection Bureau, and many of your dissents would undercut environmental protections or workers' rights or anti-discrimination laws. And you've recently praised Justice Rehnquist's dissent in Roe. You've embraced an approach to substantive due process, that would undermine the rights and protections of millions of Americans, from basic protections for LGBT Americans, to access to contraception, to health care, and the ability for Americans to love and marry whom they wish. I'm concerned your writings demonstrate a hostility to affirmative action and civil rights. And most importantly, I believe you've repeatedly and enthusiastically embraced an interpretation of presidential power so expansive it could result in a dangerously unaccountable president at the very time when we are most in need of checks and balances. I want to pause for a moment on this last point because the context of your nomination troubles me the most. In reviewing your records, Judge, you've questioned the lawfulness of United States v. Nixon, an historic decision in which a unanimous court said the president had to comply with a grand jury subpoena. You've questioned the correctness of Morrison v. Olson, a 30-year-old precedent holding that Congress can create an independent counsel with the authority to investigate the president, who the president can't just fire on a whim. You've questioned whether a president and his aides should be subject to any civil or criminal investigations while in office. And given these positions about presidential power, which I view as being at one extreme of the record of circuit judges, we have to confront an uncomfortable but important question about whether President Trump may have selected you, Judge Kavanaugh, with an eye towards protecting himself. So, Judge Kavanaugh, I'm going to ask you about these issues as I did when we met in my office, and I expect you to address them. When we spoke, you agreed that we have a shared concern about the legitimacy of the Supreme Court, that it is critical to our system of rule of law. In my view, it is today in jeopardy. You're participating in a process that has featured unprecedented concealment and partisanship around your record. And a few moments ago, Senator Durbin proposed a bold step, which would be for you to support, suspending this hearing until all your records are produced and available to this committee and the American people, and I encourage you to do this. There's also members of both parties who have not stated how they will vote on your nomination, and I urge you to answer our questions about your prior work, about your writings, about precedent and the Constitution itself, to trust the American people and to help build our trust in the court on which you may well soon serve. I've been to too many hearings in which judicial nominees have told us they'll even-handedly apply the text of laws or the Constitution only to watch them ascend to the bench and whittle away individual rights of Americans or narrow or overturn long-settled precedent. This Supreme Court vacancy comes at a critical time for our country, when our institutions of law and the very foundations of our democracy are being gravely tested. If we're going to safeguard the rule of law in this country, our courts, and in particular our Supreme Court, must be a bulwark against unprecedented violations of law, deprivations of freedom, and abuses of power by anyone, including our president. No one said it better than our former colleague, Senator McCain, who once asked about America, what makes us exceptional? Is it our wealth, our natural resources, our military power, our big and bountiful country? No, it's our founding ideals and our fidelity to them and our conduct in the world. They are the source of our wealth and power, that we live under the rule of law. That enables us to face threats with confidence that our values make us stronger than our enemies. Judge Kavanaugh, we're here to determine whether you would uphold or undermine those founding ideals and the rule of law. We're here to determine whether you would continue in the traditions of the court or transform it into a body more conservative than a majority of Americans. We're here to determine whether your confirmation would compromise or undermine the legitimacy of the court itself. I urge you to answer our questions and to confront these significant challenges. These are weighty questions, and the American people deserve real answers. Thank you, and I look forward to your testimony.
Yeah, you can easily get the impression, not just from Senator Coons, but other senators, that somehow you, Judge Kavanaugh, are out of the mainstream some way. So I looked at your record in the DC circuit and have found that judges have agreed with you and your rulings in an overwhelming majority of matters across the board. 94% of the matters Judge Kavanaugh heard were decided unanimously. In 97% of the matters Judge Kavanaugh heard, he voted with the majority. Judge Kavanaugh issued dissenting opinions in only 2 7/10% of the matters that you heard. I would also like to clarify what the Presidential Records Act requires. Our documents process has fully complied with the Presidential Records Act. Under the federal statute, President Bush has the right to request his own administration records. He also has the authority to review his records before the Senate receives them. Indeed, the archives may not produce them to the committee without giving President Bush and his statutory representatives an opportunity to review first. This is what President Bush has done, and the National Archives does not have the authority to second-guess President Bush's decision to release records to us. The National Archives was not cut out of the process. As President Bush's representative informed the committee, quote, because we have sought, received, and followed NARA, that means the archivist's views on any documents withheld as personal documents, the resulting productions of documents to the committee is essentially the same as if the archivist had conducted its review first and then sought our views and the current administration views as required by law, end of quote. Senator Flake.
Thank you, Mr. Chairman. Congratulations, Judge Kavanaugh, and congratulations to your family as well. Let me just say a few things about the issue that has been discussed here a lot today, the issue of documents and document production. The standard historically that we use to looking at nominees is what is relevant and probative. I would suggest that we certainly get that from the 12 years you've served on the circuit court, on the DC Circuit Court, that considers, when you look at the docket, items that, more than any other circuit court, that the Supreme Court would be perhaps called to rule on. In the past, senators on this panel have argued on both sides of the aisle that confirming a judge, the best we can look at is his or her judicial record. You have that record, and it's a long one, over 300 opinions, and I would suggest that that's where we need to start. A lot of the other records that have been discussed are mainly duplicative, administrative documents. Many do not meet the standard of relevant or probative. They may not demonstrate the type of justice that you will be. Senator Sasse talked about what we're called to do here, is to look at your temperament, your judgment, and your character. And I think you can see a lot of that by the type of life you've lived outside of the courtroom. When we met in my office, I was impressed, obviously, with your respect for the law and quick intellect, but also struck by kindness and decency. I found out that we share deep love of sports. We both played football back in the day. I'm sure you're looking forward to this weekend, not just when these hearings are concluded, but when the Redskins and Cardinals play on Sunday. I've learned that you've run the Boston Marathon twice. I wonder if the ABA took that into account when they gave you a favorable rating. I'm not sure what that says about your soundness of mind, myself. But in all seriousness, training for a marathon, completing 2 marathons like this is a huge accomplishment. It demonstrates not just your competitive spirit, but a strong sense of purpose and commitment, and says something about your temperament and character. Of course, you have no greater commitment than to your family, your wife Ashley, and your 2 daughters. I know that you beamed with pride when talking about them, and talking about, as has been mentioned earlier, coaching your daughter's elementary school basketball teams. I have a letter for the record written by a group of parents whose girls play for basketball teams that Judge Kavanaugh coaches. And with Mr. Chairman, without objection, I'd like to that letter into the record.
So ordered.
The team's parents note that Judge Kavanaugh has been a devoted coach and a mentor to their daughters. As these parents note, Coach K, and that's new, you, not the Duke, famous one, stresses the importance of playing as a team and has provided their girls the opportunity to learn about teamwork, honesty, integrity, humility, respect, discipline, hard work, and competitiveness. Again, we're going back to temperament and character. Judge Kavanaugh's dedication and commitment as a volunteer basketball coach, I think, demonstrates and says a good deal about that character. And congratulations to you and the Blessed Sacrament Bulldogs for winning the city championship this past year. I know you must be proud of your team. Now, aside from running marathons, winning basketball championships, you've spent, as I mentioned, the last 12 years as a federal appeals court judge on the D.C. Circuit. You have earned a reputation among legal commentators and colleagues on both sides of the aisle of a solid, careful judge, a thorough and clear writer, and someone who promotes collegiality on the court, working with people across ideological lines. I have also a New York Times article for the record written by Professor Akil Amar, a self-professed liberal who describes Judge Kavanaugh as one who appreciates the craft of judging with seriousness and commands wide and deep respect among scholars, lawyers, and jurists across the political spectrum. Mr. Chairman, I'd like to submit that for the record as well.
Objection to order.
As I mentioned, Judge Kavanaugh has amassed an astonishingly distinguished and extensive record, writing more than 300 opinions, joining his colleagues in issuing thousands of additional cases. And that is where we need to look first when we're looking at how you will judge on the Supreme Court. Now, I know, and it has been brought up today, that a lot of the concern on the other side of the aisle stems from the concern of an administration that doesn't seem to understand and appreciate separation of powers and the rule of law. I have that concern as well. If you just look at what was said just yesterday by the president, I think it's very concerning. He said in a tweet, 2 long-running Obama-era investigations of 2 very popular Republican congressmen were brought to a well-publicized charge just ahead of the midterms by the Jeff Sessions Justice Department, he calls it. 2 easy wins now in doubt because there is not enough time. Good job, Jeff. That is why a lot of people are concerned about this administration and why they want to ensure that our institutions hold. Thus far they have, gratefully. Jeff Sessions has resisted pressure from the president to punish his enemies and relieve pressure on his friends. And many of the questions that you will get on the other side of the aisle and from me will be how you view that relationship, where you believe the Article 1 powers end and Article 2 powers of the administration begin. So I expect to have a number of questions on that subject. I, again, appreciate your willingness to put yourself through this process, and I look forward to the hearing moving ahead in the next week. Thank you, Mr. Chairman.
Okay. Senator Blumenthal.
Thank you, Mr. Chairman. Thank you, Mr. Chairman, for your conducting these hearings as fairly and patiently as you have. And I am going to be remarking further on what procedurally I think is appropriate here. But I want to begin by thanking Judge Kavanaugh and your family for your commitment to public service. I want to thank the many, many Americans who are paying attention to this hearing, not only in this room, but also across the country. I want to thank them for their interest and indeed their passion. That is what sustains democracy, that commitment to ordinary, everyday Americans participating and engaging in this process. There is a T-shirt worn by a number of folks walking around this building that says, "I am what's at stake." This vote and this proceeding could not be more consequential in light of what is at stake, whether women can decide when they want to have children and become pregnant, whether the people of America can decide whom they would like to marry, whether we drink clean water and breathe clean air, whether consumers are protected against defective product and financial abuses, and whether we have a real system of checks and balances, or alternatively, an imperial presidency. I will not cast a vote more important than this one, and I suspect few of my colleagues will as well. And what's at stake is indeed also the rule of law. My colleague, Senator Flake, quoted the president's tweet yesterday. I'm going to repeat it. 2 long-running Obama-era investigations of 2 very popular Republican congressmen were brought to a well-publicized charge just ahead of the midterms by the Jeff Sessions Justice Department. 2 easy wins, now in doubt because there is not enough time. Good job, Jeff. I've had my disagreements with this Department of Justice. I want to note for the record that at least one high-ranking member of the Department of Justice was in this room. I want to urge the Department of Justice to stand strong and hold fast against this onslaught, which threatens the basic principles of our democracy. And I want to join my colleague, Senator Sasse, in his hope that you, Judge Kavanaugh, would condemn this attack on the rule of law and our judiciary. Because at the end of this dark era, when the history of this time is written, I believe that the heroes will be our independent judiciary and our free press. You are nominated by that very president who has launched this attack on our Department of Justice, on the rule of law, on law enforcement, like the FBI, law enforcement at every level, whose integrity he has questioned. And your responses to our questions will be highly enlightening about whether you join us in defending the judiciary and the rule of law. That very president has nominated you in this unprecedented time. Unprecedented because he is an unindicted co-conspirator who has nominated a potential justice who will cast the swing vote on issues relating to his possible criminal culpability. In fact, whether he is required to obey a subpoena to appear before a grand jury, whether he is required to testify a prosecution of his friends or associates or other officials in his administration, and whether, in fact, he is required to stand trial if he is indicted while he is President of the United States. There is a basic principle of our Constitution, and it was articulated by the founders. No one can select a judge in his own case. That's what the president's potentially doing here, selecting a justice on the Supreme Court who potentially will cast a decisive vote in his own case. That is a reason why this proceeding is so consequential. Senator Sasse urged us to do our job. I agree. Part of our job is to review the record of the nominee as thoroughly and deliberately as possible, looking to all the relevant and probative evidence. We can't do that on this record. Mr. Chairman, you have said multiple times that your staff has already reviewed the 42,000 pages of documents produced to this committee at 5:41 p.m. yesterday. Both sides are using the same computer platform to review the documents from Mr. Burke. The documents had to be loaded into this platform overnight and couldn't be concluded until 6:45 a.m. this morning. How is it possible that your staff concluded its review last night before the documents were even uploaded? That's this platform that both sides are using here. Simply not possible, Mr. Chairman, that any senator has seen these new materials, much less all of the other relevant documents that have been screened by Bill Burke, who is not the National Archivist. And this situation, when we say it's unprecedented, is truly without parallel in our history. And I'm going to quote from the National Archivist. It's, quote, something that has never happened before. And the archivist continued, this effort by former President Bush does not represent the National Archives or the George W. Bush Presidential Library, end quote. So, Mr. Chairman, I renew my motion to adjourn so that we have time to conclude our review of these documents, and so that also my request under the Freedom of Information Act, which is now pending, to the National Archivist, to the Department of Justice, to other relevant agencies, can be considered and judged. That Freedom of Information Act will require some time, I assume, to conclude. I renew my motion, Mr. Chairman, and ask for a vote on the motion to adjourn. As I said earlier, Rule 4 provides, quote, the committee chairman shall, not may, shall entertain a non-debatable motion to bring a matter before the committee to a vote. That seems pretty clear to me, Mr. Chairman. I've made a motion to bring before the committee a motion to adjourn under the rules. With all due respect, you are required to entertain my motion. And I would just add this final point. All of these documents will come out. They will come out eventually, as soon as 2019 and 2020. By law, these documents belong to the American people. They don't belong to President Bush or President Trump. They belong to the American people. It's only a matter of time, my Republican colleagues, before you will have to answer for what's in these documents. We don't know what's in them, but the question is, what are they concealing that you will have to answer to history for? Mr. Chairman, I renew my motion to adjourn.
You quote the rules very accurately, but those rules apply to executive business session. We're not in an executive business session, so I deny your
Mr. Chairman, with all due respect, I ask you to point to me the language in Rule 4 or anywhere else in our rules that limits its scope to executive business meetings. There is no such language, Mr. Chairman.
I would have you quote language to the contrary.
Could you quote me that language?
No, I'm asking you. You quote me a language to the contrary of what I ruled.
There is no language to the contrary. I'm asking for a vote in this session now. There's nothing that precludes the vote in our hearing at this exact time.
Okay, I've ruled. You want to proceed, do you?
Well, If the chair, with all due respect, is ruling against me, I move to appeal the ruling of the chair. With all due respect, the chairman is not above the rules of the committee. I ask for a roll call vote to overturn the ruling of the chair and to allow for a vote on my motion to adjourn these proceedings.
That would be an appropriate motion if we were in executive business session, but we're not in executive business session, so it's denied.
Mr. Chairman, I will proceed under protest. We've had a lot of rhetoric so far about rules and norms. I am very regretful that the chair has adopted this stance, which in my view contradicts our basic norms and rules, but I will proceed. Mr. Chairman, I have fears about what this nominee will do with respect to our rule of law, but also about basic rights that have been established by past Supreme Court precedent. And the only way to test what his fidelity to the rule of law is, in fact, is to ask, as I have asked every judicial nominee coming before me when I have served on this committee in hearings, whether he believes past decisions of the Supreme Court were correctly decided. So I'm going to be asking you, Judge Kavanaugh, whether you believe Roe v. Wade was correctly decided.
Mr. Chairman.
I'm going to be asking you.
Mr. Chairman, may I ask a question? I was under the impression each of us had 10 minutes for an opening statement. We'll have 50 minutes for questions. But
let me clarify.
And then plus I would ask Mr. Chairman, the various members have been making speeches all day long and have not been confined to their 10-minute opening statement.
Yeah. Okay. Well, like I told you.
I think I have time left on my 10 minutes.
You will have time. I'm going to let you finish. Just a minute. I was hoping that the 10-minute rule would stand, but we got off to a very bad start. And we got off to a bad start, and everybody started exceeding their time limit. So I guess as long as we have to stay here and get this all done today. If we have to stay into the night, we're going to stay, but I'm not going to cut anybody off now that I didn't do it right away. And like you said, mob rule, I've always said to myself when advising other people, either you run the committee or the committee runs you. And I let the committee run me this time. So let's just proceed as we have and let Senator Blumenthal take what time he wants. I hope you won't go too long.
I'll be very judicious.
Thank you.
Chairman. Thank you.
I don't know what that means.
Yeah, I don't know. He's not answering.
I'm sorry, Senator Cornyn, I can't agree with you. We just proceed. Senator Blumenthal.
Thank you, Mr. Chairman.
Next time, Mr. Chairman.
So I will be asking Judge Kavanaugh whether you believe Roe v. Wade was correctly decided, whether you believe Brown versus Board of Education was correctly decided. Judicial nominees have figured out all kinds of ways to avoid answering that question. First, they said they felt it would violate the canons of ethics. There are no canons of ethics that preclude a response. Then they said that they felt a decision might come before them, an issue in a case that might arise. And more recently, they've adopted the mantra that they think all Supreme Court decisions are correctly decided. But you're in a different position. You've been nominated to the highest court in the land, and your decisions as a potential swing vote could overturn even well-settled precedent. And there are indications in your writings, your opinions, as well as the articles you've written and some of the memos that have come to light that you believe, for example, Roe v. Wade could be overturned. And that's why I want to know from you whether you think it was correctly decided in the first place and other decisions that are regarded as well settled or long established. In fact, I have these fears because Judge Kavanaugh, this system and process has changed so radically. In fact, you have spent decades showing us in many ways what you believe. Or to put it more precisely, you've spent decades showing those groups like the Federalist Society and the Heritage Foundation and others what you believe. They're the ones who have really nominated you because the president outsourced this decision to them. In those opinions and writings and statements and interviews, you've done everything in your power to show those far-right groups that you will be a loyal soldier on the court. And I'm going to use some of those writings and some of the timing and other indications to show that you are more than a nominee, in fact, a candidate in a campaign that you have conducted. That seems to be, unfortunately, the way the system has worked in your case. The norms have been dumbed down and the system has been degraded, but I think that we have an obligation to do our job and elicit from you where you will go as a justice on the United States Supreme Court based on what you've written and said, and also what you will tell the American people in these hearings. I join in the request that's been made of you, that you show the initiative and ask for a postponement on these hearings. I think that this process has been a grave disservice to you, as well as this committee and the American people. If you are confirmed after this truncated and concealed process, there will always be a taint. There will always be an asterisk after your name. Appointed by a president, named as an unindicted co-conspirator, after the vast majority of documents relating to the most instructive period of his life were concealed. The question will always be, why was all that material concealed? You've coached and you've mentored judges in going through this process. You are as sophisticated and knowledgeable as anyone who will ever come before us as a judicial nominee. So you know that we have an obligation to inquire as to everything that can be relevant. And it's not the numbers of documents, it's the percentage. There were no emails when Justice Ginsburg was the nominee. The documents that we've been provided contain duplicates, they're full of junk. We need everything that is relevant, including the 3 years that you served in the Bush White House as staff secretary. Supreme Court. I was a law clerk, as you were. I've argued cases before the court. Most of my life has been spent in the courtroom as U.S. Attorney or as Attorney General. The power of the Supreme Court depends not on armies or police force, it has none, but on its credibility, the trust and confidence of the American people. I ask you to help us uphold that trust by asking this committee to suspend this hearing and come back when we have a full picture with the full sunlight that our chairman is so fond of espousing, so that we can fully and fairly evaluate your nomination. Thank you, Mr. Chairman.
Once again, I would remind everybody we have half a million documents on this gentleman's record. And also, I'd like to respond to the fact that you can't go 42,000 pages, which I guess is way over the number of documents that we actually received. The majority and minority received documents in two ways. One is a format that can be uploaded to reviewing platforms, and the second is in a standard document file format called PDFs. Given the importance of reviewing documents in a timely manner, my staff reviewed the PDF versions. The production was relatively small, and therefore there was no need to upload them to a reviewing Senator Kennedy. Senator Kennedy, you're next. You're next, Senator Kennedy.
Thank you, Mr. Chairman. I've listened with interest today. I agree so much with what Senator Sasse said. I listened today, and it's no wonder to me that so many Americans think that the United States Supreme Court is nothing more than a little Congress, a political body like the United States Senate. Let me try to explain what I'm looking for in a Supreme Court justice. I want a judge. I don't want a politician. Now, I'm not naive. It's true, Senator Booker and I are new to the Senate. We didn't come here when Moses walked the earth. But we're not new to politics. And I understand that human relations are about politics. I get that. But I don't think our founders ever intended for the United States Supreme Court to become a political body. I don't. I'm not looking for an ideologue. I'm not looking for a hater. What I am looking for is somebody who is whip smart, who's intellectually curious, who writes cleanly and crisply, who knows what a semicolon is for, and who is willing to protect the United States Constitution and the Bill of Rights and understands that the Bill of Rights is not an a la carte menu. Every one of them counts. Let me try to explain further why I agree with so much of what Senator Sasse said. This is not a news flash. Our country is divided. We've been divided before. We'll be divided again. We will survive this. But I confess the division in our country today seems to me to be especially sharp. And what concerns me so much about that division is the basis for it. It's not honest disagreement. So much of it is anger. There have been thousands, millions of pages written about the genesis of that anger. We all have opinions. You know what they say about opinions. Here's mine. I think a big part of the anger in America today is because we have too many Americans who aren't sharing in the great wealth of this country. Not economically, not socially, not culturally, and not spiritually. And those Americans believe that the American dream has become the American game and that game is fixed. Let me give you one example why I say that. I don't hear it so much today. I'm biased, but I happen to think the Tax Cuts and Jobs Bill Act worked. But when I ran 2 years ago, I would hear it every single day. People would stop me and they would say, Kennedy, you know what's wrong with us economically? They would tell me, I look around, Kennedy, and I see too many undeserving people. I emphasize undeserving. I don't want to paint with too broad a brush. They would tell me, Kennedy, I look around and I see too many undeserving people at the top getting bailouts. And I see too many undeserving people at the bottom getting handouts. And I'm here, just a working smuck in the middle, stuck in the middle, and I can't pay the freight anymore because my health insurance has gone up, and my kids' tuition has gone up, and my taxes have gone up, but I tell you what hadn't gone up, my income. Now, I happen to think we're doing better in that regard, but we've still got to work a long way to go. But here's the point. Who's supposed to fix that for the American people? It's us. It's the United States Congress. It's not the United States Supreme Court that's supposed to fix this country culturally, economically, socially, spiritually. And that's why I say I agree with so much of what Senator Sasse said. It's almost become cliche, but the role of a judge is, or at least should be, to say what the law is, not what the law ought to be. Now, it's become cliche, but cliches become cliches because they're true. Judges are not put there to try to bypass the ballot. Courts should not try to fix problems that are within the province of the United States Congress, even if the United States Congress doesn't have the courage to address those problems. Our courts were not meant to decide these kind of issues. I'm not naive. I know that judges aren't robots. We can't replace you and shouldn't try to replace you with a software program based on artificial intelligence. You have discretion. We're going to talk about that if we ever get to the questioning part of this exercise. But I want to say it again. I understand why, listening today, that so many Americans believe that the law, which I think all of us revere, has become politics just pursued in another way. It's not the way it's supposed to be, Judge. That's not what I'm looking for. Now, I'm going to end. I still got plenty of time left. I think I have 2 hours allotted, Mr. Chairman. Somebody talked about, said they'd seen this movie before. I commented to my friend Senator Tillis, this thing's as long as a movie. These are the words of Justice Curtis in 1857 when he dissented in the Dred Scott case. When a strict interpretation of the Constitution, according to the fixed rules which govern the interpretation of laws, is abandoned, and the theoretical opinions of individuals are allowed to control its meaning, we have no longer a Constitution. We're under the government of individual men who, for the time being, have power to declare what the Constitution is, according to their own views of what it ought to mean. That's not the rule of law. Justice Scalia put it another way, and I truly will end with that. He said the American people love democracy, and the American people are not fools. The people know their value judgments are quite as good as those taught in any law school, maybe better. Value judgments, after all, should be voted on, not dictated. And that's what I'm looking for, Judge. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Judge Kavanaugh and your family, welcome. Mr. Chairman, earlier on today, I pointed to an op-ed that had been written by two former White House staff secretaries, John Podesta and Todd Stern, entitled, "Staff Secretaries Aren't Traffic Cops. Stop Treating Kavanaugh Like He Was One." And I note in their op-ed what they said. I will quote part of it. That they said that when they handled the job for President Bill Clinton in much the same way that staff secretaries did for President George H.W. Bush, we wrote.
All right, guys, back in the newsroom here with you all. What we think is to be the bulk of a lot of the hearing today. Of course, just a lot of general opening statements there from senators at the Senate Judiciary Committee hearing, and this is going to go on all week. So we are expecting this to really kind of take over most of our days here this week. And as they go on break, you know, we'll take a little interim and show you some of the other stories that we have today. But generally, many opening statements, not even yet to the questioning. We believe that will happen on another day. And more on that on our evening broadcast with Tom Fitzgerald. He'll be covering that story today. But if you want to continue watching this particular stream, we have another view sort of the open room there from our sister station in New York. So you can join us on our Facebook page, Fox 5 DC, for more of that as it continues. We're going to keep that up live for the remainder of the afternoon. So more on this hearing later this week. And continue to follow us on digital, all of our platforms, Fox 5 DC. And if you're watching on our website at the bottom, fox5dc.com, we'll be there again tomorrow at 11:30, just like today. All right, guys, catch you then.